wanted your lordships to note, my lords. I have submitted a volume 3 small compilation. Your lordship need not open it, your lordship just note, my lords, if your lordships doesn't mind, my lords. That is about how spouse is understood in section 5.1.
There's something called annexure 3.
Annexure 3. Compilation.
I don't know.
Compilation 3.
Circulated last night.
What's the volume?
Volume 3.
Volume 3. My lords.
105 pages, right?
Volume 1, Volume
Yes.
2, amended written submissions.
Amended.
Yes,
Annexure 2.
compilation
Annexure
volume
2.
3.
Is it annexure 2?
Compilation volume 3.
Oh, yes, compilation volume 3.
At
है,
page-
वहीं पर है, उसके नीचे है.
Volume 3, yes.
What is the
PDF
page?
161.
205.
Pages?
205 pages.
161.
This was what he doesn't. Got it.
Lalita Gupta.
Yeah. 159.
Is that 2011?
Yes.
2012.
That's right.
This is Kaju, I think.
This is
You said PDF 161, which is actually a judgment called
Lalita Gupta.
Leela Gupta.
Leela
Gupta versus Lakshmi Narayan,
Leela Gupta, my lords, at paragraph 13.
para 13.
My
Yes,
Lord Justice Bhatt has it.
I'm just trying.
160.
Is it
If the Lord
PDF
will come,
161?
PDF.
my Lord Justice Kohli, my Lord has it.
59.
Put it to 161.
Got it? हाँ भैया
Yeah.
मिला आपको?
Just above para 14,
Yes.
6 lines. The word spouse has been understood to connote a husband or a wife, which term itself postulates a subsisting marriage. The word spouse in subsection 1 of 5 cannot be interpreted to mean a former spouse, because even after divorce, when a second marriage is contracted, if the former spouse is living, that would not prohibit the parties from contracting the marriage. So only emphasizing this word spouse, my lords.
All right.
Although
What
that
else?
is apparent, Lord, this is one judgment which my learned colleague could find out. Lord, on
All right.
this.
What else?
Now, Lords, on the issue of originalism also, this is not in the compilation, Lords. In 2017-12 SCC, page 1, Jindal Stainless,
Yes.
para 184 and 202,
Would you repeat it, please? 2000.
2017,
Yes.
volume 12 SCC, page 1, Jindal Stainless, para 184 and 202,
On original interpretation.
on, my Lord, the entitlement of the court, my Lord, to look into, or rather necessity to look into the Constituent Assembly debates. There are a large number of judgments, but this is 9 judges,
right.
so, my Lord, I just picked this out.
Not necessary to read it.
Not
We'll just
necessary.
take it. Yes.
Because n number of judgments are there, not where your lordships have looked into this.
Oh, yes.
Of course, Lord, I don't mean to say, Lord, that
But
things
they're
are
binding on
frozen.
things. Yes.
That's not the contention. The contention is what I wanted is, Lord, that
Much-
what are those circumstances, what are those limits, Lord, on ignoring, Lord, so there has to be something really
All right.
fundamental, Lord, which has an
Right.
impact. on
Point
that.
is taken. Yes.
That's the
All right. What is the next point now?
Then coming back to the written note, Lords,
Final written submission.
yes, final written submission.
Yes. Final written
At page 9, there were 3 cases, Lord, which Mr. Vishwanathan cited. Well, also will find these 3 cases I've dealt with, Lord. Then D.S. Nakara, Lords, and Vishnu Das. They were both on, Lords, administrative orders.
Cut-off date.
So it had nothing to do with a legislative enactment or a constitutional provision. So reading in, or reading up and down, Lords, all those principals were not involved. Cutoff date was struck down in Nakara's case. And Vishnu Das, there was it's a transport matter, where the scheme found discriminating was struck down. And in association of old settlers also, it was a
Illustrated.
case of striking down some portion so that old settlers could also be accommodated. In none of these cases, not anything was read into any enactment, that too of a substantial nature, as is sought here. On Ghedan, my lords, much has been said. By the learned Solicitor General, all of which I adopt, my lords. If your lordship turns to page 14, kindly just note, Lord, that in Ghedan, my lord, I have extracted here, the Secretary of Council for the Secretary of State had conceded. And in the light of, Lord, amendments which were already before the House for permitting same-sex partnerships. And Para 128, Lord Roger has recorded that. He records, certainly Council for Secretary of State who made submissions in favor of interpreting Para 2.2 in this way did not foresee any such problems in reading like that.
Where
It's
are you
also
reading that,
Para
Mr.?
14,
Page 11, I
14,
think,
bottom.
page 10.
Clause D at the bottom of page 14,
Yes.
third line. He records, certainly Council for Secretary of State who made submissions in favor of interpreting Para 2.2 in this way did not foresee any such problems. It is also notable that by the time this judgment was delivered on 21/604, the bill relating to civil unions was already under consideration and ultimately received royal assent in December 2004. So these were the circumstances in which, and that too was a minor change which was done. But what is more important, you shall find in F. In MacDonald observed as below, if the court implies words that are consistent with the scheme of legislation but necessary to make it compatible with convention right, it is simply performing the duty which Parliament has imposed on it and on others. So it was a parliamentary act which required the court to make it compatible and tell the House. It is actually, this is an advisory jurisdiction, because as the Lordship saw in section 3, which I have quoted at page 12 and 13, kindly at page 13, subsection 6,
Yes.
a declaration under this section does not affect the validity, continuing operation, or enforcement of the provision in respect of which it is given, and is not binding on the parties to the proceedings in which it is made. So this is a very peculiar, it's not a provision of judicial review at all. It's more like an advisory jurisdiction,
What's
Lord
that? What's the
43,
next point, Mr. Gadvedi?
which separation of powers then will
All right.
in fact, Lord, after the court has given the judgment in Kedan, well, Parliament is quite competent, Lord, to take another view by passing an amendment. Lord.
All right.
Now, so far as separation of powers is all well settled, my lords, and I will only request the lordships to note the judgment at page 19. This is, my lord, the Chief Justice's judgment, my lord. I'm sorry, my lord, the word J is missing there.
Page 19.
Satpal Saini.
Yes.
Para 12 particularly, the lordships have said that each branch is equal, and there should be no encroachment. The courts do not frame policy or mandate that particular policy should be followed. Duty to formulate policies is entrusted to the executive. The accountability is to the legislature and through it to the people. The peril of adopting an incorrect policy lies in the democratic accountability of the people. That's para 12 at page 20. One interesting feature, my lord, to be noted is about separation of power is Article 50. If your lordship looks at it for a second, It talks of, that's the Constitution of India, my lords, Article 50.
Separation of the executive judicial.
What do you want us to look at, Mr.?
Article 50 in the Constitution of India, separation of powers. my lords. My Lord Justice call has, my lords?
Yes, yes, please.
50-50.
50.
Separation of judiciary.
Oh, yes.
The state shall take steps to separate the judiciary from the executive in the public services of the state. It doesn't talk about parliament, my lord. Now, there is significance, my lord, because I have quoted a number of articles where, my lord, parliament has in the judicial domain power to make laws, my lords. At page 21, your lordship will find in bold.
You know, actually, Article 50 was enacted in a different context, because actually, even after the Constitution, until recently, there was no strict separation between the executive and the judicial functions, especially in the district judiciary. The idea was to ensure that, you know, the district magistrates, for instance, don't exercise the powers of a civil court. Even today, until
There are some
recently, in the
places
Northeast, for instance,
Even today.
even
by
today,
roots of,
Commissioners and all that.
If you could have a, if you
But
could have a
I have not drawn the lordship's attention to say that this is something decisive about the range of the manner.
broadly the
But
the drift.
because separation of powers is to be deciphered by referring to all provisions
the
of the
best exposition
scheme of the
is in
Constitution.
Indira Gandhi. Is in
Yes.
Indira Gandhi.
Yes.
What is separation of powers in India?
So,
All right,
entirety of
let's,
the Constitution
but
has to be read.
Mr. So Dwivedi, this is very well settled. I think we
Yes,
can
yes.
move on to the next
yes.
point.
No. What is it? Kindly, my lords, just note, my lords, three cases at page 24 and 25, where writ petitions demanding a common civil code, your lordship said it is for legislature. Then Hindu Adoption and Maintenance Act, my lord, your lordship says areas and aspects or facets of Hindu law which require modernization, modification, alternate are matters of legislative policy. That is 24 bottom, and then at page 25.
of your note.
Yeah.
Then we read.
Udesh, Maharishi.
Page 24 bottom,
Got it, got it.
and running to page 25. There are three judgments where in the field of reforms, social reforms, your lordship said that it is for the legislature. The last one, my lord, is an order, my lords, in writ petition number 319, which wanted the court to intervene with regard to dowry menace and so on. Your lordship said legislature.
All right.
Then next page, I'm not reading, my lordship, some foreign judgments are mentioned in the same direction.
Same-sex marriage. 29 numbers.
If your lordship comes to page 29, this is in the same sex context. My lords. Oh, okay. This Obergefell, my lord, of course, is there, but we have quoted there also at page 26, 27. Just take the same view, and if your lordship recollect, they only issued a declaration leaving it to the.
11 states have already legislated.
Oh, then page 29 is Shoot Attorney General of Michigan versus Coalition to Defend.
Right.
Where the same, my lords. And 32 is Israel, where a foreign marriage, my lord, was the issue to be, it was not being registered in Israel. Para 33 is Panama, my lords, and it also mentions Thailand. These judgments are there in my compilation, lords. I'm not reading, it's all in the same direction. Interestingly, Panama is very close to America, my lord, yet discordant note. Now, kindly, Kamala, then I come to Article 14. Because the first question is there a fundamental right, my lords, for persons in same-sex relations to marry, my lords, either flowing from Article 14, 15, or 21?
Mr. Dvedi, apropos a discussion which we were conducting between the three of us and my learned sister, does anyone have a fundamental right to marry?
But since certain judgments
Forget
have,
the issue of same sex.
yes,
Does anyone have a fundamental right to marry? Or is there no fundamental right to marry at all, according to you? Because your submission is that no one has a fundamental right to marry. Or is it, what is your answer to this?
my submission is simply this, my lord, that so far as heterosexual
No, we are
marriages-
not on heterosexual.
That's why keep
We,
aside
we
this.
see that's what
Concept
actually
of
triggered
marriage.
this idea.
Yeah.
yes,
Does any citizen of this country for whom this court and our society and our polity has placed the individual at that highest pinnacle, and we have gone ahead and carved out, or rather discovered, so many rights: the right to personhood, the right of choice, the right of being left alone, the right of
Autonomy.
privacy, autonomy, which is at the core of personhood,
And dignity above all.
dignity, which is part of our preambular promise.
yes.
Now, with all this, what is the question? The core question is, does a citizen or a person have a right to marry? Is it part of 21 or it is not part of 21? Granted that, but that in that sense, there is no unqualified right. We have to start with the premise that there is no unqualified right. The right to free speech is not unqualified. The right to association is not unqualified. Personal liberties are not unqualified.
Right to life itself
Right
is not
to life
qualified.
is not
Can be
unqualified.
taken away on
Therefore, we
conviction.
don't start with there is no unqualified right. There is no absolute right. If we start with that premise, what is the right? Does the right to life have that concomitant of the right to marry? So do not start the debate with whether same-sex people have the right to marry. Rather, what is the right to marry? Is there a right to marry?
So my submission is that the heterosexual couples have a right to marry in accordance with their custom, personal law, and religion, and that has been continuing. That's the foundation of their right. Now that right has been
So, but therefore you concede the fact that therefore there is a right to marry under the Constitution, but that right to marry is confined only to heterosexual persons, according to you. Or is it your argument that there is no right to marry at all as a fundamental right?
I'm saying there is a right to marry which is founded on customs, personal law, and religion. The
In
enactments
that case,
passed,
as you taking the same argument further,
yes,
custom, culture, religion. Rewind 50 years ago, intercaste marriages were not permitted. Even go back further, Sapinda marriages were not permitted, right?
So there are-
Interfaith marriages were unheard of,
yes.
right? So all this, the content of marriage has changed. Therefore, what was that fundamental right to marriage in
So
1954?
these changes,
Core content.
What is the core
these
content of the
changes
definition?
therefore have been brought about by legislation, and legislature can certainly, my lord, alter the customs, and now, my lord, the ghost of
The
Larasu has been,
Maybe keeping aside for a moment the legislative aspect, as you said, it's the culture, it's
Yes.
the customs that has brought about this whole matrimonial setup. Keeping that legislation aside, would you say that you're referring to the relevant articles of the Constitution? Is it that it is based and founded in the Constitution, the right to marry? Is the question.
so the Constitution only gives a fundamental right to form relations, associations, which is there in 19(1)(c), which can be regulated.
Persons.
Now, what we call our association as marriage has ultimately, over the course of years, resulted in a social institution. It's not an overnight something happening, Willard, and two people coming together and say, call it marriage. So it's a long period of time where this institution of marriage has emerged, and as a result of society's evolution.
So even prior to the Constitution,
Yes,
there was this whole customs, ceremonies,
absolutely.
and all of it.
Yes.
Once the Constitution came in, is it your argument that the marriage was
So that right to
Correct.
marriage, which was existing as a part of social institution, will be accommodated in the right to associate in a particular manner and in a particular social institution. Asking to open the doors of this social institution of marriage as existing for them. And that's the plea, that we stand at par for various reasons and therefore make the amendments in the SMA. SMA has now become unconstitutional, violative of Article 14. It may not have been violative of Article 14 in 1954-56 when a cluster of laws were codified.
By the same token, Mr. Dwivedi, Constitution has not granted anything. Go by the theory of the dissent in the habeas corpus, or even by what is generally accepted. It only recognizes and guarantees. Nothing is granted. We are free citizens. We have taken this onto ourselves. So the right to speak, the right to associate, everything is part of our inherent rights.
That's
The
right.
Constitution,
Yes.
therefore, does not grant.
It-
So even the legislations have only recognized. So that right to marry is inherent. If we say the right to marry is inherent, it is part of the Constitution. You may locate it in 19, you may locate it in 21, perhaps appropriately 21. Because 19(1)(c), the history you see brought was in terms of association, as we understand.
So it doesn't matter where
Yes.
where it is located or taking together it is located somewhere along with the preamble.
As we normally define a natural right.
That's right.
But the right to marriage in the sense in which
This is the problem. The moment we qualified with in the sense, because
That's
when
important.
you bring in the tradition, now the Constitution itself is a tradition breaker. The Constitution is a tradition breaker because for the first time you brought in 14. If so,
so
let me
I
just
appreciate.
complete. If you brought in 14, if you brought in 19, 15, and most importantly 17, those traditions are broken.
It can be broken.
No. Therefore, just allow me to continue with that thread for half a minute. If those traditions are broken, what is held hallowed in our society in terms of caste? We made a conscious break and said that we don't want it. We have even gone to the extent of encapsulating let's say an outlawing untouchability in the Constitution. I don't think there is any constitution in the world which says this shall be an offense as a part of its fundamental right. Therefore, traditions are there to the extent they are there. To the extent they have created the tradition, the institution of marriage, they are there. But at the same time, let us also be alive to the fact that the concept of marriage has evolved, which you yourself said.
No difficulty, Millers. Everything, a lot of evolutions have taken place. Other side has also adverted to them. We have also adverted. The point is, all these reforms which have happened are reforms, Lord, which are made by the legislatures in the interest of women and children. And they do not alter, my Lord, the fundamental aspect, the core aspect of the social institution of marriage as it exists, namely that it is an institution, it's a marriage, rather, my Lord, Hindu marriage, they regard it as a sanskar. So, as a sacrament, the fact that now divorce has come in, or my Lord, the fact that some other modifications have.
Yes, you're right. That is
So-
by and large, but
So, but
even Hindu,
each and every reform, my Lord, kindly see 1937.
we are looking at what we understand as the traditional, but there are large parts of society. It's a very diverse Hindu society. That diverse society even today, and that's why you have Section 29 of the Hindu Marriage Act. You have customary divorce, which is preserved. Therefore, divorce existed in many communities.
Yes,
The diversity is there. That diversity we cannot.
correct. So, therefore, my Lord, what I submit is that the core aspect, what is the core aspect of that marriage?
That is that.
You may provide for maintenance, you may have alimonies, you may have divorce on certain grounds, you may provide that there will be intercaste marriages, but ultimately the marriages remained heterosexual marriages. And number two,
Mr. Dwivedi, there are certain, to state at the extreme that there is no fundamental right to marry under the Constitution would be far-fetched. what are the core incidents of marriage? If you look at the core incidents of marriage or the core elements of marriage, not the incidents, I made a mistake. What are the core,
element.
what is the core content of
marriage.
marriage? Or what are the constituent elements of marriage?
Lord-
Just one second. If you look at each of these constituent elements, each of them is protected by constitutional values. I'm not saying 21 necessarily, but constitutional values. The
Yes.
preambular values read with 14 and 21. One, marriage itself postulates the right to cohabit, right? Of two individuals to cohabit together. Two, marriage accompanies with it the notion of a family, the existence of a family unit, because the two people who come together in a marriage constitute family. Again, something which directly owes its existence or recognition to the constitutional values. Three, to bolster your submission, we must take that into account also. Marriage has procreation as a very important ingredient of marriage. Though equally we must be cognizant of the fact that the validity or the legality or the social acceptability of marriage is not conditional only on procreation, for the reason that people may not want to have children. People may not be in a position, have the ability to have children, or they may get married at an age when they cannot have children. But we therefore take your point that procreation is a significant facet of marriage. There's no denying the fact, subject to these caveats. Four, marriage in a significant way is exclusionary of all others. Two people who come together in a marriage or want to cohabit together are entitled to exclude everybody else from that area of marriage. No third member of society can say that, well, I want to share in the same relationship which you have with one of you in the marriage. It's exclusionary of others. And five, which is equally important, just I gave you that thing about procreation, which is social acceptance of the existence of marriage. And social acceptance is then not just confined to that individual, but to the how society itself looks at that institution. Now, having said that, there cannot be any denial of the fact that the state has a legitimate interest in regulating marriage. Undoubtedly. Therefore, the state that's how the state regulates the forms in which you can enter into marriage. The state regulates how many people you can enter into a marriage when you have a subsisting marriage. The laws against bigamy, for instance. The state has a variety of other interests so that it regulates various facets of marriage. But we must therefore accept as a basic proposition that marriage itself is something which is entitled to constitutional protection, and it is not just a matter of statutory recognition.
No,
Once we cross that threshold, then we enter into the next level, which is the contested issue here. Is heterosexuality an intrinsic or core constituent element of the institution of marriage? Your submission is that as marriage has evolved, and even today, whether heterosexuality has social acceptance or not, is one thing which regulates the state's interest, because the state has a legitimate interest in regulating in marriage, and therefore it may say that I'll not recognize anything beyond a heterosexual relationship for the purposes of marriage. That's your contention.
no. So may I respond on this?
I just want to add something. Actually,
Yes.
the Chief Justice has, I had written something and the Chief Justice has virtually echoed the same thing, but I put it slightly differently.
Yes, Manoj.
I'll just read it out. What is the content? After all, what is a marriage to each other? One is to society. What a marriage to each other, each spouse, they decide what that marriage means to them. So what is the content of a marriage is defined voluntarily by the parties. That is the spouses. They decide, number one, whether to have and raise children, the procreation part. It is entirely their choice. Of course, there are social pressures. We are all aware of it. But ultimately, at the core of it, whether I will have child or both of us will have children or not is our autonomous decision. There may be marriages where parties may not live together. There is no cohabitation in that sense. Both are working. They may be meeting each other once or twice or 5 times or 6 times as they choose. So the concept of cohabitation. There may be no matrimonial home in the traditional sense. Marriages may not have any element or varying degrees of physical or sexual relationship. Now, therefore, as to what is the content, context, or cultural central to a marriage depends ultimately upon the participating, spouses. Is that right?
No. With great respect, no.
So you mean to say that if people...
This
No,
this
please,
thought.
please, I'm looking at the voluntary part. I'm not looking at the...
Yes,
this-
I appreciate it. I appreciate what falls from my Lord. But that's the great debate which has been going on ever since the time of Kant and Hegel, my lords. Kant said, this is pure
And
contract.
keep the heterosexual element outside. We are not on that at all right now.
No, that's very fundamental. We can't leave it aside.
No. We are not saying that that is not relevant. We are saying we are testing the core proposition in regard to the content of a marriage.
Because one view is globally prevailing that some say that marriage is simply a contract. It's up to the parties to define, my lord, what marriage is. Marriage becomes a fluid concept completely, my lords, and that's one concept. And that, my lord, what are the consequences of this, my lord? I'll show to your lordship, my lord, by when I read the Nussbaum's article, my lord. She goes up to saying that then you will even have to knock down the prohibited degrees. She says that the state will have to provide justification in the court, my lord, why these prohibited degrees, my lord, cannot be. The health aspect, etc., has been knocked down scientifically. So therefore, knock down prohibited degrees. She even goes to the extent of saying there are 2 pages I'll like to read. Then they can, why not brother and sister can marry?
But that is not, that doesn't pose a constitutional problem to us because that's not.
No,
what you
no,
just a second. There you recognize the legitimate interest to the state to regulate. Now, what we are trying
where
to
do we
say-
stop? Legitimate, because state has to come and justify why we are banning prohibiting marriage between brothers and sisters.
Of course.
Mr. Dwivedi, it's not as absurd as that, with due respect, because I think, in all societies, barring a few, these prohibited degrees of relationship exist in some manner or the other. Age restrictions exist.
So, again, we go back to the history, etc., and then see, my lord, that in Muslims it's a different.
Something
in
even more
Hindus, it's
fundamental.
different.
There's something more fundamental. Apart from blood relationship, there is marriage relationship. For instance, sisters-in-law, brothers-in-law. Why is that relationship? Why is that prohibited? There is perhaps a very deep-rooted, public interest in that.
Of course, there is.
That is of some kind of order.
Yes.
Orderliness. So all these are legitimate state.
But therefore, the state has a legitimate interest to find out, Lord, what is that order, Lord, which is to prevail in the society, given society.
Mr. Dwivedi, that is not being questioned.
So I'm saying that if you treat this marriage as a fluid concept, which individuals in the 2 spouses are to define for themselves what it is, we don't need any law, etc. Then each couple will be deciding, Lord, what marriage has meaning
Sorry,
for them.
I didn't mean that no law. I said there is a law. There is a law. I'm talking even of heterosexual. Nobody is compelled to have children. Nobody is compelled to live together.
Lord, that's the greatest of difference, I say. It is one thing that some couples, heterosexual couples, may decide not to produce. Some couples may marry and may want to, but they are unable to produce because of infertility, of medical reasons,
You just
biological reasons.
go
That
go
would be-
outside the precincts of this building and some of these complexes. You see construction workers, you see migrants who are away from their houses most part of the year. They go back barely for 15, 20 days. What is that family life? What is cohabitation for them?
So we are on the aspect of marriage, my lord. Family life will vary from case to case, my lord,
Exactly. This is
but marriage will not. With great respect, my lord, marriage cannot be made so fluid, my lord, so undefined. Marriage has the core purpose, as I was submitting, my lord, when your lordship put this query to me, is to bring about a unity of man and woman, my lord, for a social purpose. Because society needs to perpetuate itself, the race needs to perpetuate itself. Some may not produce, some may be infertile, these don't decide. The generality is that our population has grown from 44 crores, my lord, to 1.4 billion today, my lord, it's not because of certain people, some who did not decide to produce or were unable. We have reached here because, in generality, people want to come together, they want to cohabit, they want to, my lord, engage in sex, not merely for pleasure, not merely, my lord, for taking care of each other, but for building a family of their own, something out of their own body and flesh. It's all right, some people can adopt. These are exceptions. But the real thing is that we all want our own child and we try for it. We want it. That's how the family is built up. That's how the family, the child who comes into being, we builds the relation, my lord, with the relatives. So our concept is different. Take any religion.
Mr. Dwivedi, if you therefore formulate and articulate the core content of a marriage, how would you do that?
Core content is the coming together of a man and a woman as commanded, as even Bible says, when Adam and Eve were there, that they blessed them for happiness and say, go be fruitful and multiply.
So therefore,
Every religion says procreation, my lord,
definition is that procreation is the definition of marriage.
this society cannot survive. And so look at the problem faced by China and Japan, and today it is being said, my lord, by statistically that world is facing the problem of aging. We can't have IVF, my lord, and adoptions. In fact, adoption, what is adoption, my lord? Some heterosexual union has produced some children, my lord, maybe an orphan, and you adopt. What is IVF, my lord, and surrogacy? It's coming together of an egg and a sperm, my lord, together to produce a zygote. So ultimately, your family, your efforts to wanting to build something is dependent upon a heterosexual union. That's the fundamental truth. That's the most essential law of nature. That's the cosmic unity. And the society, my lord, cannot survive. Nations cannot be. What is national integrity, my lord, if this society grows old and there are no children? So producing children, bearing and rearing children, we don't want to go to the America way. Maybe there are, again, point out some families here, my lord, who are impressed by that, and where children leave the families at a young age and they are on their own. So everything is not beautiful there, my lord. And I have a very strong criticism of Justice Kennedy's judgment, Justice Sachs' judgment, and Nussbaum, Professor Nussbaum. They treat marriage as a pure and simple contract, my lord. It's not a pure and simple contract. It's the most sacred phenomena, my lord, on earth, and not confined to human beings, my lord, but to other species, plants, and so on.
So when you talk of right to marriage, which is what you were referring to, so marriage in any case transcends the constitution. It is not looking for its sanctity within the framework of a constitution, having predated it by several decades, years, centuries. So when you
And as your lordship said, my lord, that the constitution enables the legislature to regulate. Over the course of years, we find development of society, my lord, we find certain things which were good at one point of time are no more good. We today want equality within the family. So that's one more change. Bigamy again is a protection. These are all laws which are protected under Article 15.3. 15.1 doesn't affect it. 15.3 commands the state to make special provisions for women and children. Bigamy is to protect women. Maintenance is to protect them. Alimony is to protect them. So therefore, all these laws which are being made, our rights are not, the heterosexual marriages don't depend upon this. No constitution can take it away. That, I will put it like that. It's a natural right.
That's right.
By virtue of our being human beings. To deny that right means to let the nation die. That's the importance of this. And that's what Chief Justice Roberts in his dissenting judgments emphasized. And Justice Sachs in his judgment in Fori says, my lord, that this is not the essential characteristic of marriage. That's how the underpinning, two underpinnings. It's a pure, simple contract dependent upon two individuals, and secondly, my lord, it's not essential characteristic. I am therefore addressing your lordships not to follow the path of Obergefell and Fori, my lords. The path, they make a declaration. One was, my lord, to insert it. We have already made a submission, my lord, that SMA, my lord, you can't, it's not possible to insert by altering. And the other is not to, my lord, the other course of action would be, my lord, that, all right, make a declaration that they are entitled to marriage at par with heterosexuals, and therefore, and leave it to the parliament. That was one plea by Mr. Vishwanathan. So I am dissuading your lordships, my lords, from making any declaration in that context. Because those two judgments of one is majority, one is unanimous, both are fallacious. Their underpinnings are completely wrong. In India, we don't treat marriage not as a simple, pure, merely because there is a consent. Even, Lord, I have annexed in the recent compilation, Faizi's, Lord, Muslim law. He was an ambassador to Egypt from 48 to 52, and then vice chancellor of the Jawaharlal of the Jammu and Kashmir University. And he has written, my lord, that it's not, even there, this concept that it is pure contract is incorrect. You need a Qazi, my lord, presence. You need to recite verses of Quran, and therefore, so it's a mix. Something like seniority come merit and merit come seniority. My lord, in Hindus, it is sacrament plus contract because some consent is obviously implied. If that is to be treated as contract. And that is where my lord Hegel comes in, and Hegel says, criticizes very sharply and says it is shameful for Kant to say that it is a pure contract. And he applies the principles of contract and says that contract involves parting and exchange of externalities. When marriage happens, Lord, there is no exchange of externalities, no promise and acceptance in the sense of Indian Contract Act. So yes, consent is there. Both couples agree. If that is said to be a contractual element, yes. But it's not a contract in that sense. And the two judgments treat it as a contract. These are essential things. Why we treat it as a contract? Why the religions, all religions, even though they are in conflict with each other on so many things, yet all of them regard not the homosexual relation as a sin. Your lordships have declared it to be not a crime. But what about that, lords?
But the moment you say that it is not just a matter of mere contract, but there's an element of a sacrament, which is again a fundamental precept of our law, at least insofar as Hindu marriages are concerned.
The fundamental precept of custom and
undoubtedly that a marriage is not a, I mean, that's the first thing which we learn when you learn the sense of Hindu law.
Yes.
But marriage is not merely a matter of contract; it's a matter of a sacrament.
Sacrament.
Once you accept the fact that it's not a matter of a pure contract, but it's a matter of a sacrament, then it's a sacrament which is also impressed with a constitutional character.
So I have no issues. The lordship may find it located somewhere, but it doesn't depend on that. Your lordship may find its continuance there. What was existing up till 1950, by the coming of the constitution, is not transformed into something which is by virtue of the constitution.
That can be said of anything else.
Yes.
Everything else.
Absolutely.
You see,
It's not that we didn't exist as a society and the constitution switched us on. No.
And that's the basis on which we overruled ADM Jabalpur when we dealt with ADM Jabalpur in Puttaswamy. We said that the fundamental fallacy of ADM Jabalpur was that if Article 21 is suspended during the period of an emergency, that does not suspend your right to life. Because your right to life does not owe its existence to the Constitution. It's a recognition by the Constitution. Therefore, the power to suspend 21 will not suspend your right to life. That was the whole basis.
I have no problem because
Right. Now, therefore, once you say that, well, marriage is a sacrament, then you have to accept that marriage as a sacrament traces its origin to 25, therefore.
because my submission doesn't turn on this acceptance. Your Lordship may locate it. I have no issues.
Right.
Your Lordship may treat it as part of life itself. I mean, if that is so fundamental, the right to life and personal liberty, so right to life itself will be marriage.
There is a fundamental right to marry within the meaning of the Constitution.
So right to life
So
itself
we
is
are
marriage.
only joining issue with you that there is no fundamental right to marry.
No, I
You
never.
began by saying that there is no fundamental.
No,
right to marry, which is really
thrust,
constitutionally
I'm sorry,
involved.
because my thrust is been that there is no equality. Don't make a declaration that the marriage which is to be
So what
declared.
in other words, in terms of constitutional, let's say, precept, there is a right to marry. Understands that it is that can be confined to heterosexual, but there is no marriage outside of that. There is no right to marry outside. Of that. So there
In
is
that
no-
sense,
and then
they
in
may,
that sense, everything else.
it
falls
is up to
under
the parliament. If the parliament
That's-
wants to create artificial definitions and declare it,
So
fine.
for instance, there was no prohibition of bigamy in
Yes.
Hindu marriage. So it was brought
Came
in.
in 56 for the first time.
For that marriage matter, there was no concept of divorce. As you say, sacrament, it is still sacrament, and yet there is divorce. Correct? It is still a sacrament among Catholics even now. And yet, if they want any one of them, they go into that and get divorced. So Parliament has that, overriding whatever
That's right.
authority.
They
to the
can
extent
define marriage, redefine marriage, or create a separate law.
Exactly.
Define their relationship, my lord, in some different manner as many other countries
There's
have
no
done.
quarrel about that.
That's true.
It's ultimately in that. If it has to be, ultimately Parliament may have to do.
Out of 195 countries, only 44 countries have recognized same sex. Maybe less.
And Mr.
34.
Dwivedi, then it leads us to one other issue, which is that assuming that you are right for a moment, that it is open to the state in the exercise of its legitimate interest, either to recognize a broader notion of marriage which goes beyond heterosexuality, or to confine it to heterosexuality. That the state has a legitimate interest in saying that we will define marriage in such a way as would promote vital societal interests, including social acceptability or the stability of the social order. Equally, even if you were to concede that, there may be an alternative formulation. And that alternative formulation would be that apart from the element of heterosexuality, there may be other elements of that associational relationship which to a certain extent must find protection within our law, even if it were to be short of marriage, even if you were to accept your point. Ultimately,
What recognition, my lord, if your lordships are contemplating some sort of recognition from the state to that relationship is essential in order to protect, my lord, afford protection to their relationship of love and affection, etc., family or adoptions or some other civil benefits. It's ultimately up to the parliament to decide what sort of recognition is to be given, to what extent parity needs to be given. I have at page 58, if your lordship will turn to my, I have set out at least 10 aspects of recognition which will have to be born in, and only parliament can do it. Just look at page 58 if I'll just go back.
Mr. Dwivedi, again, what you are saying is not something which is lacking absolutely in substance.
I mean,
There is a germ of substance in what you say. But equally, there may be, it's a more nuanced or a layered argument. One is sort of a constitutional recognition of the components of an associational relationship short of marriage. Two, the administrative or civic incidents of that relationship. And three, legislative recognition. Legislative recognition, legislative regulation, legislative acceptance undoubtedly has to emanate from Parliament. No question about it. Two, the administrative or civic consequences of a relationship, which the Solicitor General said that we are, obviously the government has taken the first step forward by saying that the government is going to constitute a committee chaired by the Cabinet Secretary. Second, but even more fundamental, in some ways, and not so fundamental because ultimately it has to see progress on the ground, which is how do you define and how do you give meaning to the content of constitutional values? So even assuming that we accept your submission on the legitimacy of marriage as a social institution, the stability of the order, the legitimate interest of the state in protecting the concept of marriage as a heterosexual relationship, or deciding to what extent you will also dilute that concept, it's a matter for the state's legitimate interest and parliament to regulate. Equally, there is, even in this area that we are debating, some element of constitutional jurisprudence left for the court to evolve.
Well, sir, with great respects, the court will not be issuing a declaration which is amorphous, vague. Some sort of recognition needs to be given. I mean, a declaration emanating from your lordships has to be concrete and definite, which results in something positive straight away in their favor. Else,
Is it that something, are we in a society, a constitutional society, and we are now approaching our 75th anniversary? Are we in a state where we say that a declaration by the state, by one of the co-equal wings, which is tasked with interpreting the constitution? I am not
Yes.
saying exclusively, because other wings also are entitled to. When it says that this is it, and beyond that it will not say, it cannot say, because it cannot implement it.
And we are
Right?
conscious of the fact that we cannot tread into the legislative domain.
There are limits.
So once we say that, does it not have its own force? Are we trained? Let me complete. Let me just complete.
Sorry.
Is common law seeped into our bones to this extent that everything that we say needs to be executed through contempt or through some execution proceeding? Is it not sufficient that the court says that this is the state of affairs, and that's out there for the people, for the parliament, and other branches of governance, including constitutional branches of governance? And I'm not talking of only the constitutionally recognized branches of governance, the society at large, that this is the state of affairs. How it is assimilated is not up to us.
I'm certainly not saying that lordship's jurisdictions to make an
No,
appropriate
I'm taking
declaration
it-
is not there.
Yes,
That's not
I'm
my.
taking it beyond the writ of mandamus. I'm
What-
just
what
taking it.
what I'm requesting and beseeching your lordships is that please do not issue a amorphous, vague, too general a declaration which has no meaning.
But take the case of privacy, right? We located privacy in constitutional precepts, but we were conscious of the fact that if we have to implement
So your
privacy in the concept,
reference in a pending proceeding, with great
In
respect,
regard to
certain
what?
questions are
What is
every day
the-
referred.
So what is the
That is
content
quite
of 30?
different.
Mr. Dwivedi also argued. We all know that. It was only argued what is the content of 30. It was in the abstract.
No,
Why you're finding it difficult? What we are talking about, both Chief Justice and Justice Budd is talking about, if there is a right, it's a recognition of a right. The order of a court is in the context of recognizing the existence of a right. It's thereafter for the legislature. Court might not be able to do or take up any executive action to implementing it.
so
Once there is a recognition and court stops there, it is thereafter for the executive
that's
to take
precisely
it up.
where I'm, my lord,
And it's
engaging
one of
in-
the most important and
No, I appreciate, my lord,
function
but
of a
this
court
is
to give a
precisely where I'm
recognition.
engaging in this debate, my lord, is that when it comes to recognition of a right, then this is a sphere. What sort of recognition your lordships will be providing?
Absolutely, you're right.
That's the
Now, let me just state 10
that's
points. my lord.
exactly what we are also deliberating on.
matter.
We are sort of introspecting at this stage. We are now almost towards this last third of the arguments. That's why we sort
So
of
in fact, that's one of
we are
the
also in a
core
state of
functions the court.
mental
No, I appreciate.
churning.
It's important, my lord, for such debates to happen, and therefore, my lords, I'm requesting your lordship just to listen to this, my lords. Now, if your lordship wants to, sorry, my lordship.
No, please.
Go ahead.
Please.
If your lordship is considering, hypothetically, I'm taking.
And Mr. Dwivedi, a lot of what we say to you is not only meant for you, it's also meant for the other side.
My lords, by now, my lords,
You are fully
at the
aware.
fag end of our careers, my lords, we are aware of all this, my lords.
You're conscious of that as much as we are after long
Many a
experience at the
times.
bar.
That's how it is.
That's how it
Quite
is.
learning
always.
a lesson from it.
churning process.
Yeah, of
And
course,
I
my lords.
think in a way, we, all of us here are privileged to
In
go through
fact,
this exercise of the mind.
One important aspect of this proceedings is, you know, that there is churning in the society. People are,
Right.
because of this debate, there is,
Absolutely.
and because of the live streaming, so in different corners of the country, people are thinking about it.
There is
And
a-
there are, you know,
Mr.
reactions.
Dwivedi, so many which ways actually. The live streaming of court proceedings has really taken that our court absolutely to
different
the homes and to the hearts of common citizens. And I think that's part of the process. I
The
mean,
only thing is
obviously-
that our debate happens in English language, and in the villages, etc., people will not be able to follow, my lord. And the language problem in India is very complex. So,
But you'll be surprised. We are working even on that, Mr. Dwivedi. Even
Yes.
that is not lost to the Supreme Court on its administrative side.
Live audio
We are
translation.
working on this. You see that transcript which you
Yes.
have there?
It's being
We're
translated.
now trying to use technology to ensure that the live streaming content can be
Yes, immediately.
simultaneously made available in
That's
languages
great.
which the citizen can
In
follow.
fact, technology now allows,
Of course.
if you are speaking in English,
Subtitles.
Speech to text.
simultaneously be heard in Japanese
Yes, correct.
without a translation.
We have it.
It's speech to text.
Mr. Sibal.
Mr. Sibal,
Mr.
it's
Sibal,
speech
it
to
is
text.
right.
Telugu,
Yeah, or speech to speech as well.
Ah,
already,
not only it's available.
Yes.
It's very much available.
And that's the beauty of it.
that's the beauty.
We must put
Basically, Malas, we are in the midst of a tectonic shift in societal values. Where we recognize it, where we stop is the issue before the court.
Absolutely.
That's the issue.
So there are 10 aspects, my lord, which will arise.
Now, Mr. Dwivedi, as the
page 58.
as the head of the family, I have to now hurry you along. We are in the thick of debate with you, but we need to now just hurry along so we get everybody else
So
a chance.
just let me just,
Yes. Now, just 10 points if you can formulate so that we can then
It's
take it down.
already
Yes, you
there.
have put it down.
That's what you are saying, D9, right?
Yeah.
page
So let's quickly
58,
look at it and then
page
we'll wrap up.
58.
Page 58. No?
D9. D9.
Yes.
D9.
D9. So there are various aspects of recognition, my lord, and therefore I am submitting, my lord, that this has to be left to Parliament, my lord. It can be debated there only in the legislatures. So many aspects are required. And unless all of these enter into your lordship's consideration and some declaration comes, my lord, which measures all these.
Let's see D9.
The claim for recognition gives rise to several questions. That is, what sort of recognition needs to be given? What form of recognition should be given? Should the recognition be given by inclusion in an existing law or means of a separate law? Should the recognition be given at par with heterosexual marriages? To what extent parity needs to be given? Should parity be given at one go or in phases? What should be the spacing of phases? What will be the repercussion of granting par with either heterosexual marriages or transgenders? Determination of whether a majority of same-sex relations and transgenders desire particular recognition with all consequences. Whether the society is sufficiently ready to accept the particular kind of recognition to be given.
Thank you, Mr. Dwivedi. Can we now wrap up, Mr.
Now-
Dwivedi? I think you've made your point on this.
Now, my lords, on 21, my lord, Mr. Rohtegi said,
Where is your 21 argument, Mr. So we can just quickly run through that.
D10.
well, just a word about Article 14, where I was, when this the lordships put questions to me. And that is not that.
Mr. Devi, why don't you do this? You're right, we interrupted you. In 2 minutes, you can now wrap up your Article 14 arguments. We have the overall perspective so that you can just
I'll
sort of put
quickly
it
just
together and
formulate each one of them, my lords.
Page 32, Chief.
On Article 4. Drawn attention to two aspects, in addition to what has already been submitted by the learned Solicitor General. The first is, my lord, that when this Act, Special Marriage Act, was made in 1954 and the other codifications, at that time, there could be no discrimination at all because of existence of 377, which came to be struck down much later. So at that time, when the Parliament was confining itself to making certain regulatory measures, codifications with respect to heterosexual marriages alone, there could be no contention raised that at that juncture, my lord, it was. So the only question will be, my lord, what has happened subsequently is only Navtej which has decriminalized, which comes, my lord, now, 4 years back. Is the consequence of this change such that these laws or any of them become discriminatory and violative of Article 14 now? There are cases where Lordship said that a law may be good when made, but subsequently some supervening change may have happened, my lord, which may result in its becoming discriminatory. So it cannot be, my lord, this law immediately on a declaration in Navtej results in these legislations or some of them becoming discriminatory and therefore requiring, my lord, whether it should be altered or not. Because the question of alteration arises only if this has become discriminatory. The second aspect which I wish to submit is that in view of the core idea of marriage which I have submitted before your lordships, in view of the immense continuity, my lord, the enormous continuity of these customs, etc., even today, it cannot be said that this has become discriminatory because these laws have not been amended to accommodate them. So the question of knocking down this does not arise. Particularly keeping in mind, my lord, that Parliament is fully entitled not to make a comprehensive legislation. After decriminalization, there has to be a process. How long it will be or not, one doesn't know. It is for the Parliament to assess and decide when to come out with what law. It cannot be said that now this judgment, Navtej has come, so within 4 years have passed, nothing has been done, and so now make insertions, amendments. Now at page 42, my lord, is Article 15. My respectful submission is, my lord, that 15.1 doesn't have any impact because most of the regulatory laws and the substance of them is to provide protection to women and children. And it is protected, therefore, by Article 15.3. That's one. The second is, my lord, at page 43, in Indra Sahni's judgment, the majority view emphasizing the presence of the word only. I have extracted that portion at page 43. Your Lordship will have the last 4 lines. When in such circumstances, provision is made for reservations, for example, on the basis of caste. It is not a reservation in favor of the caste as caste, but in favor of a class or social group which has been discriminated against. And discrimination cannot be eliminated otherwise. What the Constitution forbids is discrimination within court only on the basis of caste, race, etc. However, when the caste also happens to be a social group which is backward or socially and educationally backward or a weaker section, the discriminatory treatment in its favor is not only on the basis of caste. So therefore, the word
That goes as far as it goes. In that
Yes.
context, it's 100% right. But there can be other shades to this only. Supposing you're while employing someone, you say you belong to, let's say, Uttarakhand, and therefore I'll not employ you. And say you also there are other factors.
all I'm saying is that the word only therefore has to be established. If it is only on the ground of region or religion
I'm
or
putting
something,
it the other way, Mr. Trivedi. This only has to mean something else, in my opinion. Of course, I'm speaking against the grain because Nargesh Mirza and other previous judge only cannot mean that these proscribed ground can also be there plus others. Can you say while employing? I'm not talking of reservation. That somebody is
so
an
it,
ST or an
it
ST.
cannot be any plus plus. Any insignificant plus plus. That
anything
my Lord
else
Justice
plus.
Chandrachud
I
has
said that
said
in Navtej.
in Navtej, your Lordship
Also
has
the
said.
army women's
By
matter.
way of
Yes.
emphasis.
So I'm not meaning that. Then any insignificant plus plus something.
So
and therefore-
discrimination otherwise on the ground of gender will be valid,
But
so long as it is a discrimination on gender and some other attributes.
bracket it
That's
with
not,
other
that's not how you
but
interpret Article 50.
but if the other attribute is a major one, which is also being factored, then yes, it will have a play, my Lord. That's what I'm submitting. That's what follows from.
Then
And
this
our theory has gone far beyond, Mr. Dwivedi. Now we have spoken about
Indirect.
intersectional discrimination.
Even so, my Lord, we can't ignore the terminology which has been deployed there of only, my Lord. It can't be ignored. Yes. As far as I'm concerned, I will
Then
say
you
that
see,
any
then it becomes
insignificant or
very
minor
difficult.
plus will not
You
make
have
a
to give
difference.
that content.
Correct.
But
The
here-
word only has to be given a content,
Content,
which is
that's
more
all.
compatible with the
Otherwise-
Constitution as we see
But
it
here
today
the-
evolve.
But here, proceeding further, my Lord, the question is, we are taking note of one sexual orientation. Moving forward, my Lord, one sexual orientation which is resulting in the same-sex relationship. But there is the other sexual orientation which is involved in the heterosexual marriages, which I have already elaborated. My Lord, it's not that that is not a sexual orientation. That is also a sexual orientation, particularly when the women are being protected and is squarely following under 15.3. So that sexual orientation is of coming together for the purposes for a good of the society. The procreative good is a good of the society itself.
That point you have made, Mr.
So, but that's also a sexual orientation.
All right, thank you, Mr.
Now-
Yeah, I think we can now go on to Mr. Civil. I think we have given.
Just
adequate
one,
time.
my Lord, if I may just submit a paper, my Lord, about why, my Lords. There's a 2 pages which I have given to your Lordships.
Today?
Yes.
Is it part of the?
नहीं, ठीक है, दे दो. Just have your junior email it also so that it becomes a
I
part
think it
of
has
the.
been emailed.
No,
but Justice
just email it to the court master. So it'll become a part of our electronic file.
Thank you.
Other side goes.
So Dwivedi, this you have already stressed actually. You have spoken about why Kennedy and Sachs are wrong and why you don't accept Martha Nussbaum's writing. We'll have a look at it, Mr.
The
Dwivedi.
Lordship may have a look.
Yes.
I'm grateful. my Lord.
Thank you very much, Mr. Dwivedi. Yes, Mr. Sibal.
Won't take too long, Mullah. Lordship has already, Mullah, gone through all the law.
Does he have a written?
Mullah,
I don't know.
I've sent my propositions, Mullah. They're already hopefully before your Lordships.
Yeah.
Under what head? What head?
We also have printed.
No,
have
Mr. We
posted
don't
that
have
with
that.
the-
don't have any of
If you can have some, your junior,
We've
email it
circulated.
to the court master, we'll immediately get it.
We have circulated it, Mullah, but
No,
we'll give you the print.
Nothing. Not on the,
It's been,
just
then.
just sent.
I've got physical copies
No,
also.
let's do it on the electronic form,
Yeah.
all of us.
All right. Give it to them.
Mr. Sibal, what happened to your iPad?
I have it. Mullah, I have it and I'm going to honor, Mullah, my commitment to your Lordship.
We had to do
In this field at least, my lords.
to do it in other courts too, besides court
No, it's a
one.
temporary measure.
Is it a proverbial elephant's, tusk?
No, no, my lords. In fact, I have been assiduously, my lords, trying to learn on a daily basis, my lords, and I've managed, my lords, quite well. My lords, I'll start off by saying, my lords, that I was very worried, my lords, at the outset of the hearing, when on the other side it was said that Parliament is not going to do anything about it. We don't expect Parliament to recognize this particular right. And therefore, we urge your lordships to give us a declaration. Because I'm afraid that that's a very dangerous proposition.
Sorry, will you repeat yourself, Mr. Sim?
I'm sorry?
Will you repeat yourself?
Well, it was said, Malaj, at the outset, that we don't expect Parliament to move forward. We don't expect Parliament to pass such a law. And therefore, your lordship should do it. And I said, Malaj, that's a very dangerous route to take. Any law of this nature, Malaj, which is pursuant to a tectonic shift, as I said, Malaj, in societal values, requires public discourse, which includes discourse in Parliament, it includes discourse outside Parliament, within the assemblies, outside society. And therefore, my lords, a declaration by itself on the premise that Parliament is not likely to pass a law, my lords, is, as I said, a wrong step forward. But my lords, let me go to the heart of the matter. When your lordships were dealing with Nalsa, you got it?
What's happening in 40?
16. 18.
It's a dangerous route to take, my lords, because a declaration by your lordships will close the debate in Parliament. There will be no scope of debate once you declare. One, that it's a fundamental right. Two, it has to be recognized. That's, my lords, with the greatest respect, my lords, something that your lordship should be cautious about. Nothing more than that.
Parliament can overrule a declaration also, no?
Sorry?
Parliament can overrule a declaration.
No, my lords, your lordship knows that once your lordships have declared, Parliament cannot overrule it. I hope, my lords, that stage has not come for Parliament to overrule what your lordships decide. I'll be on the other side when that happens, my lords. But my lords, let's my lords, go to the heart of the matter. In Nalsa, your lordships decided sexual identity. Sorry. In Nalsa, Malad, your lordships decided,
Nalsa, you say.
yes, sexual identity, nothing more than that, of transgenders. In the privacy judgment, your lordships decided upon the contours of privacy, both in the private space and the public space.
Can you say that again? Nalsa was a declaration.
Yes,
Identity.
there was a
What
declaration.
Identity.
Yes, exactly. On sexual identity. In privacy, you decided on the space for privacy, both the private space and the public space. That even the public privacy must be protected. In Navtej, you decided on decriminalization.
So conceptually, you say the third one is slightly different
Yes,
because it is only a decriminalization, which is statutory.
correct. What you are today deciding are two things: sexual unions and recognition by the state of sexual unions. That's the issue, Malaj. None of these issues, Malaj, were looked upon, decided, contemplated, thought through in either of the three judgments. So any Malaj reference is made in the context of those three particular issues decided in those three can't Malaj be taken as concepts which must be a fortiori accepted by your lordships. Right? So first you have to decide, are they a separate sexual identity? And in the ultimate analysis, Malaj, my answer will be yes. The next step, should they be recognized by the state? The answer is not through a declaration. This broadly, Malaj, is going to be my submission before your lordships. And Malaj, I respectfully, Malaj.
Just a little clarification. Your first question was, are they a separate sexual identity? And you said yes.
Yes.
Second, should they be recognized by the state? And your answer was not through a declaration.
No, their sexual identity, yes.
Yes.
Right? Once your lordship recognizes it, then the question arises, sexual identity as a sexual union.
No, I just had a little clarification because, I'm just
Yes.
putting the submission down. Second point was, should they be recognized by the state?
Yes.
To which you said not through a declaration.
Not through a declaration.
Now, when you say should
Not
they,
through a legislation, I said.
not through
A legislation. No,
No,
it can only be done through a legislation.
yes, that's right. I took it down
So
like
you're,
that.
you're basically you're advocating a Scalia-Roberts approach.
Yes.
Right. Now,
Absolutely.
when you said, Mr. Sibal, when you said should they be recognized, that's what my question.
That sexual identity,
The sexual
which is
union.
separate from sexual union.
Sexual union.
Union.
Not sexual identity.
No, identity, Malad, I want your lordships to give that declaration.
So that word they, we'll just modulate it.
Yes.
To the sexual union.
Union, yes. Now, the question then arises, is this sexual union a marriage? That's what we've been debating, Malad, for the last an hour or so.
It was the third?
Is this sexual union akin to a marriage? If it is akin to a marriage, is it founded in any provision of the Constitution? Next question. And then the third,
Rotate.
for it to result in certain rights, it can only be done through recognition by the state, through legislation. There can't be a declaration to that effect. Well, it's when your lordships ask the question.
Constitutional perspective, the constitutional lexicon,
Yes,
when you say can't,
yes.
the can't has to also fit into some constitutionally recognized prohibition.
Yes, which
You
is,
would say
Madad, that it's a regulatory exercise of rights ultimately have to be regulated.
No, that-
Regulation can only be done through law.
No, that's right.
Yes.
That's part of regulation. We are on a more fundamental path.
Yes,
Declaration.
yes,
Well, we have now evolved to the extent of understanding what are constitutionally manageable standards,
yes.
existence of it, non-existence of it, matters which are not to be gone into the court by the court, etc. Where would you look at that? When you say a prohibition is prohibited,
Manoj,
a
I tell
declaration
you,
is prohibited.
moment your lordships decide that this union is a marriage, in what context will you decide that, Manoj? Ultimately, what is a marriage? The marriage is only a union.
No, forget the issue of whether the court should declare this to be a marriage.
Yes.
We are now on the core issue as whether the court can issue a declaration.
That it's a marriage.
No,
that is a union.
That the court can issue a declaration.
A declaration qua what, Manoj? That it's a sexual union. That's all, Manoj. It can't be doing anything
Yes,
more than
you're
that.
right. See, there is no declaration in vacuum or vacuum.
No, Manoj, there can be, Manoj.
Of course, you're right, but see that the court has in its repertoire a right to declare right from 1960, Justice Subbarao, I think that Kochuni onwards, which is there. Question is, what is that declaration we have to issue? Will it be marriage or not marriage or something?
No, that's the question that, Manoj, I'll try and address your lordships on, but that's the really core issue.
So the court has in the past issued declarations, for instance, declarations which postulate that the implementation of the declaration requires legislation being enacted by Parliament.
Yes,
The right to a clean environment, for instance.
yes.
The implementation is ultimately for Parliament to say health, education, which eventually the right to primary education found expression the Right to Education Act.
Yes, absolutely.
Or the
became
right
a
to
constitutional
food.
right thanks to a certain declaration.
Or the
I
right
agree
to
entirely.
food, which eventually resulted in the enactment of a legislation.
I'm with you on that, Manoj.
Therefore, at its core, is a constitutional precept to say that the court cannot issue a declaration would not be correct. Equally, we take your point that don't go into an area where you declare a right to marry, because that's Mr. Dwivedi
That was
has
the
argued,
intent. That was the intent. That was the intent. Manoj, let's first of all define what marriage is before we move forward. And Manoj, my
Yes,
Lord
we'd like
Justice,
to
but your
have his
lordships,
assistance
Manoj,
on that.
let's look into that. Ultimately, what is marriage? Forget about, Manoj, the law of 1955 Act. Forget all that, Manoj. Marriage ultimately is a union. It's a union of two persons. It's a sociological phenomenon which deals thus far with heterosexuality. Thus far. It's a union, Malaj. Even if the 1955 Act were not there, Malaj, it's recognized within and without as marriage. When I say within, by two people, by that union, and without by society. So there are two elements to it. Recognition within, recognition without.
Could you just elaborate on that a little bit?
Well, as for example, I mean, as I said, in the absence of a law, this union of two people with all the sacramental vows is accepted by a large majority of society for thousands of years.
That's the recognition without.
Yes, that's the recognition without, right? And that's essential. That's essential.
So the recognition without, according to you, then is the social recognition.
Is the social recognition. Thus far, it applied to only heterosexual couples. But It's still a marriage, but a marriage which is gained acceptability over centuries. The union between sexual union between sexually people who are homosexuals or whatever is still a union. You can't say it's not a union. They have a sexual identity which is separate. It's involuntary.
Involuntary?
In the sense, well, it's involuntary in the sense that these are their sexual.
It's not a matter of choice.
Yes.
That's what they call as ascriptive.
Yes.
See, in that
They have no
sense,
choice in the matter. That's how it is physically.
it could be said of both in that sense.
Sorry.
Could be said of both sets.
Yes, of course, of course.
But that apart, it is voluntary in the sense that they choose.
Of course, I don't mean.
Just like in this.
The manifestation is involuntary. Otherwise, it's of course a voluntary union. I don't mean that, Malas. It's consensual. It's voluntary.
Your sexual orientation may not necessarily lead you to a union.
That's right. It may not. It may not. That's what I'm saying, Malas. Therefore, we are not talking about sexual orientation here, which is what I was started with. We're talking about a sexual union, and we are trying to give that a name. That's what we're trying to do, Malas. That's why you'll also ask the question, what's a marriage? Right. Right? You give it a name. Now, they may consider that this is my marriage. Who can stop anybody? How can anybody stop them from considering that this is a marriage? Nobody can stop them. There are two people who decide that they want to live together. They live together for 10 years, 15 years. They say, I'm married to him. The moment you say now without, you must recognize it, comes the problem. You may find it in 21, you may find it in 14, you may find it anywhere else. You may not find it in the Constitution at all. According to me, it's part of your right to be and to live as you please without interference from the outside world. It's part of privacy.
And according to the recognition without, if the court were to be invited to give a declaration of recognition without,
yes,
that would amount to an imposition on others.
That's the point. That's the point. That's the core issue before your lordship. That's really the core issue.
If I could just translate it in a very colorfully, maybe not so. It's like drawing a blank.
Yeah.
It's like firing a blank. So which means that you allow it, but outside, without, there is no acceptance, there is no.
That's really the heart of the problem.
The counterpoint to that is, there may or may not be, but that lends us dignity in our own eyes. That lends us acceptance among our society.
Yes.
And the society without, to that extent, limited extent, among our parents, among those people who are willing to accept us. That is a point you may have to do.
True, Malad. That's certainly an issue that your lordships will have to consider. But the point that I'm making is, Malad, at the moment, what are they asking? They say under the Special Marriage Act, the rights given to heterosexual couples should be given to us. That's what they're asking. That's their ask, Malad. Nothing short of that. And that's what your lordships is considering.
Mr. Sibal, when we opened the discourse, we confined it, of course, we confined them to the Special Marriage Act with the idea in which we still maintain that we are excluding the whole gamut of personal law from the debate.
Yes.
But we're not really confined only to the contours of the Special Marriage Act in deciding the broader constitution.
That I know, 14, I'm going to come to that, Malas. That's the other issue. Is it discrimination? That's
So when we locate the nature of marriage, the institution of the marriage, we're not really then confined only to the Special
I agree,
Marriage Act
Malas.
or its
Therefore,
statutory contours.
I agree entirely. Therefore, your lordships are also considering whether there's discrimination under 14 or not. And therefore, can you then say that this is discriminatory? But where does it go from there? That's the next question. If you find it discriminatory, where do you go from there? That's an even more difficult task, Malas. First, to find that it's discriminatory, that itself is an issue, Malas. Because we are talking about separate sexual identities and unions.
That will continue after
Yes,
that.
we'll continue.
Mr. Sibal, roughly how long will you take just to have a...
I won't take much time, Malas. I'm not going to trouble your lordship with all the judgments. I'm just taking the dialogue forward, Malas, so that your lordship knows.
Because now we've seen the judgments. We like some assistance at the intellectual level now, and
Yes.
we just forget the judgments unless there's something somebody else.
That's correct. That's correct. That's what I'll do.
After Mr. Sibal, who will be taking over? Mr. Datar will be, and after Mr.
Yes, after
Datar,
me,
Mr.
Mr.
Jay Sai Deepak. So Aishwarya will be arguing. All right. Then
Just about half an hour, not
so we've Mr. Datar, Ms. Bhatti, Mr. Ms. Manisha Lavkumar, and then Mr. Jay Sai Deepak. So we would tentatively, this is not the sort of a bench which wields a guillotine, but tentatively we'll keep it for lunch tomorrow for this side.
I think so.
So that then the other side will
Yes.
conclude their rejoinder by tomorrow afternoon.
That's fine. Deeply obliged.
Mr. Solicitor, do you want to? Mr. Solicitor, Justice Bhatt has a very good idea. Mr. Solicitor, you emphasize the general part of your designation and ration the time between your team now.
That's already been done.
That's it.
All right.
That's it.
Yeah. I think so.
Sorry, brother call. Sorry, everyone. We were a little delayed. Yes, Mr.
So we were talking about acceptance, Malad, just before the break. Now, acceptance is also at three levels. The first is the acceptance by the two individuals themselves, right? That's the seminal level. Then is acceptance by the family. In many cases, there may be acceptance. In some cases, there may not be acceptance or vice versa. I don't know. I don't have the data.
And by society.
And then, Malad, it's a concentric circles which has three Malads, like public order, your lordships will
Yes,
remember.
that's what is Lohiya, Ramana Lohiya.
So there are three concentric circles
Freedom
here.
of speech.
Now, who is to investigate that? This is the problem, Malad. This is the issue. Who is to look at that? And there we need the aid, Malads, of all kinds of data, opinions, conversations, discourses, debates. If you look at the conversations, discourses, debates, if you look at the quintessential form of marriage, which is heterosexual couples, why has it stood the test of time, Malad? Because at all three levels, there is acceptability. That right to that union, Malad. You may call it by whatever name. But if you want to, Malad, equate it to a heterosexual union, you need all the elements which go into the heterosexual union being recognized. And if you look at the institution of marriage as an organic evolution, of custom and usage, you will realize that its roots in here, in societal acceptance, along with concepts of societal standards and morality. Now, that concept of morality may change, societal standards may change as they are changing. Both societal standards and morality is changing. But it inheres in that. Why can't, Malads, you marry your son's widow? It's nothing to do with blood relationship. It's something to do with standards, which the state recognizes as state interest.
Some the state imposes,
Yes, some state imposes.
Others the state recognizes because it's inherent to order.
Correct. I agree entirely. Entirely. Well, supposing I were to say it's a matter of choice that I want to have, three of us want to live together and we want to marry. Well, nothing wrong with it. I mean, conceptually, there's nothing wrong with it. Where will you place it? Will you call it a marriage? And Justice Roberts asked this question of a pluralistic relationship to counsel who were arguing. And he said there was no answer. He said that time has not yet come. So choice by itself is a slippery slope because it is
Say
elastic.
that again. Three people want to live together.
That's right. It is elastic. Choice is elastic, Malaz.
No, there are societies.
Yes, they
Maybe
do.
minuscule, but there are polyandrous.
Of course.
I mean, that perhaps is not there.
That's
but it
correct.
is there in our society.
No, I agree, but therefore, does it get recognition in the form of law? The question is that, Malaz, that's the question before your lordships. I am not being moralistic about it.
No, without being moralistic,
Yes,
we
I'm not.
do recognize
It's
that.
the reality. It's the reality. It's the reality. So when you base it on choice, it becomes somewhat difficult. And if you base it on equality, it's even more difficult. Now, let me assume that Parliament were to pass a law tomorrow in respect of same-sex unions. What if that law is challenged saying that you are treating equals unequally? Will you strike it down? You won't. That's the answer to the question. 14 requires equals being treated equally. Equal work for equal pay for equal work. You can't equate a practice that has the sanction of society for hundreds and thousands of years with
His question. Still be upheld.
You can't essentially equate these two unions, Malaj, in one class. You can't essentially do that. Therefore, this debate of procreation, love, trust, all that, Malaj, is really beside the point. Just as you can't deal with transgenders in the same class as same-sex. Can't deal with that as same class as heterosexual. So you'll have to have separate regimes. To what extent will you recognize? To what extent you won't recognize? Whether you will give them some civil rights. But I think the starting point of that is recognition of their sexuality, of their sexual identity. It is my request that this court declares that. They have a separate sexual identity. What will happen? What will happen is what happened in Kedan.
Then, Mr. Sibal, if we declare their sexual identity, as you quite justifiably you are saying that we must, then the court may also then have to contemplate what are the rights which are concomitant to
I'm
the
coming
declaration
to
of
Malaz, I have, in fact, all this is in my paper, Malaz. I'm not troubling your lordship.
Just to play the devil's advocate.
Sorry?
just to play the other complete extreme side. Supposing you declare that there is a sexual identity, as you saying,
Yes.
as you are saying that you declare a sexual identity, and supposing Parliament comes up with a DOMA,
Yes.
DOMA,
Yes. You strike it
that's
down.
DOMA.
You'll strike it down.
Why?
I think so.
You have a
Because
sexual
I'll-
identity, but you will not enter into
I
marriage.
come
You will
back
not-
to your lordships and have it struck down. But Malas, I want to say something else to your lordships. That what will happen if you do that? Malas, I am here, Malas, at the center. I am to assist your lordships, Malas. What will happen is Gaidan will happen if you do that. In your rent relationships, Malas, you will automatically get the right for the spouse to. What happened in Obergefell was that under the US, gay people were not entitled to military service. They were not entitled to government service. They were discriminated against qua immigration. None of this is happening to our people here. Apart from immigration, they can enter government service. Nobody asks them a question. They can go to any space they want to go. So we are far more liberal in that sense. The US court was dealing with essentially an illiberal environment.
We're also dealing with a situation where an individual in her or his capacity is entitled to adopt a child, but merely by dint of the fact that you are in a same-sex relationship, that right to adopt even as a single individual is denied.
I agree, but there are people have adopted, Mother, that's not an issue. People have adopted children, even in these relations, even today. There's no issue at all. There are adoptions today, mothers, that we know of by same-sex couples.
Mr. Sibal, may I say something?
Yes, sorry. Mother.
See, when those adoptions are taking place, they are proceeding on a declaration that one of them is adopting. So it's not a declaration.
I agree.
A relationship.
That's true.
And that's in that context, this one of the circulars which the Chief Justice had flagged had come into being and would be addressed by the Additional Solicitor General while appearing for the adoption group. So
yes, your lordship is right.
There is
what the circular does is, the circular says that though you are entitled to adopt as a single person, merely by virtue of the fact that two of you are cohabiting together, we'll deny you the right.
That's where you incrementally need to expand. This is precisely my point.
Absolutely. That's the point we are also
That's
making.
the point, I am also making. That you should not make a declaration at this stage, allow this to incrementally expand these rights once you give that identity. That's very important, Malad. Most of these cases, Malad, Ontario versus MNH also deals with the same situation.
But the moment you recognize sexual identity, Mr. Sibal, then how does a court then deny the fact that you are entitled to a recognition of certain other rights which flow out of that sexual
No, Malad, that's for the state to do. This is the problem, Malad. Your lordship is now doing something which the state will do in the context of what the state feels is the best interest of the state.
So are you saying, if I may try and
Yes.
decipher, that you don't recognize what is sought, but declare that they have a right to sexual identity?
Yes.
Full stop.
Yes.
The rest is up to the political process.
Yes.
The political process means the democratic process, not merely legislation.
Yes. Yes.
There has to be, this thing has to play out.
Correct.
A social awareness.
That's right. Some of them can be, sorry, I'm interrupting.
Interaction.
Yes.
Like rights are fleshed out, and that's how legislations and laws are made.
Correct. And administratively, some of these things can be resolved administratively also. So allow it to organically, grow instead of an imposition through a declaration. This is my suggestion, It's all for your lordships to consider.
Mr. Sibal, are you suggesting that in the appropriate context of the Solicitor General saying that a committee of presided over by the Chief Cabinet Secretary will look into the administrative issues. So is it your suggestion that if this declaration was to be given by this court, coupled with the administrative aspects which should be dealt with by the committee, and a third aspect would be at times maybe in a request to the legislature to look into enacting a suitable act to deal with this scenario. Is that what you are suggesting?
But it's not the third step. It's not the third step.
No.
Actually, you should allow the administrative committee to look at innovative solutions to deal with the issue. But that will facilitate the process, Malaj. If you don't do that, give that declaration, it won't facilitate that process.
And what is the apprehension of the third? One is not directing a legislature to do it. That's not what is being said.
Well,
I had in mind would be to call upon the legislature to debate this issue.
Malaj, no, I don't think you should do that either, Malaj. It's
Okay.
my request, Malaj. I don't think that in the context of separation of powers, Malaj, that's not what should be done by the court. Malaj, your lordships have not done it before. Your lordships have, what have your lordships done in all these cases, Vishaka and others? I'm sorry. Yeah. So, Malaj, so what I was saying was, and that is a given, Malaj. Nobody can dispute that fact that they have a separate sexual identity. Nobody can dispute that fact. Even the government has not disputed it. So that's a given, Malaj. You are doing nothing more than what the reality is. Now, Whether that has got acceptance or not, at what level it has got acceptance, is something that will be decided, Malaj, in another forum. And to what extent that acceptance, Malaj, is to be translated into a legal framework or an administrative framework. All the other issues, Malaj, Kwesh, Vishakha, and all are procedural guidelines that your lordship said. Procedural, not legal. Those are procedural guidelines in all of those cases. They are not substantive law. So Malaj, by and large, I have Malaj covered a large area. Kindly look at my note, Malaj, now. Give you enough time so that you... Malaj, just the first part is perspective, which is, what is the perspective with which, sorry, Malaj. Lordship has that?
Yes.
5 Supreme Court judges are being asked to close the debate in Parliament and in the public space through a declaration that same-sex marriages must be accorded the same status as heterosexual marriages. Then minorities...
The Supreme Court judges, the Supreme Court.
When I say 5 Supreme Court, it's the Supreme Court, Malaj.
Yeah.
When it's 5
So we're
distinguished
just sort of clarifying that.
No, Malaj, of course.
Even in a judgment of 7-6, the decision of
it's
13,
3-2, Malaj.
not a judgment of 7.
Obergefell was 5-4. It was the U.S. Supreme Court, Malaj. I know that. I know that. When I said Malaj 5, I meant Malaj numerically. Yeah. Minorities of all hues, like minority opinions, are protected from institutional discrimination, but they cannot demand as of right that they be accorded a status that should only be bestowed through legislation. That marriage is a heterosexual union granted societal approbation over centuries. It is not a historical coincidence. The premises that support the institution of heterosexual unions is a sociological phenomena which has endured for thousands of years. The essence of the petitioner's claim now is that the state must change its definition of marriage. This is the issue. History teaches us that when a paradigm shift of the law is at stake, the judgment of the court reflects its wisdom and restraint, which is predicated upon its understanding of the consequences of such a paradigm shift. In essence, liberty means freedom from executive intrusion into spaces protected by the Constitution and not entitlement to government benefits. This is the perspective with which, Malaj, I request your lordships to look at this issue. Then, Malaj, the quick summary of arguments. The Special Marriage Act of 54 is not violative of 14, 15, 19, 21 by virtue of being limited to heterosexual couples, as under 14 and 15, opposite-sex marriages and same-sex marriages represent 2 different classes. This is based on historical evolution of marriage as a social institution and unique dynamics between the partners. The Act is therefore not in violation of 14 and 15. Under 21, there may exist a right to choose one's partner as a function of privacy and dignity. Hence, members of the LGBTQIA+ community are at liberty to choose their partners as per the customs and usages as evolved, if any. However, there is no fundamental right to the legal recognition of such unions by the legislature. As of now, the only recognition that is available in law is in respect of unions between man and woman. The Act is therefore not in violation of 21. Refer to Puttaswamy, the passages, Malaj, I don't have to, your lordships are already aware. then, Malas, I'm very strongly opposed to this reliance on foreign judgments, quite frankly. Foreign judgments where same-sex marriages are delivered in the context of the socio-cultural environment of the relevant country and in specific factual contexts. Therefore, they cannot influence the decision-making process in India. However, they provide valuable examples of the following. One, the necessity of public discourse and engagement with the issue of same-sex marriages. And two, incremental changes in law and policy on same-sex marriages and concomitant rights. Well, as I've given, Gaidan refers to it. And then Millard's Minister of Home Affairs, Fori, and the Constitutional Court of. In all cases, Millard, there has been huge public discourse, huge. And there are paragraphs after paragraphs that refer to it, Millard. The legal recognition of same-sex marriages is a matter for Parliament to reflect and act upon. The LGBTQIA plus community may be declared as a sexual minority, just as transgender community is recognized for their separate gender identity. This is another aspect that your lordships may explore. It's akin to minorities, which must be, in a secular constitution, must be given protection. So there are two-pronged, Millard's, declarations that your lordships can think of. One, their separate sexual identity, and as a sexual minority, protection of the state. They are also a sexual minority, and minorities in a secular state need to be protected. So the protection in a secular state available to minorities generally should also be available to sexual minorities. Persecution.
I would put it in a wider perspective. Minority in a democracy. Every minority in a democracy.
Yes, I agree, Malad. I agree.
Yes.
When I said when secular.
You need not.
All right.
Here, there are minorities which are not. You see, there's a certain connotation.
I understand. I appreciate
discrete
that. I was
discrete minority concept.
I agree, Malad. I was only thinking in the other context. Yes, I agree. Broadly. So these are two areas your lordships can think of, Malad, taking it forward. Now, Malad, let's come to the text, purpose, and intention of SMA only contemplates to deal with heterosexual marriages. The court cannot interpret the enactment and declare that the SMA covers same-sex marriages through any process, according to me, misinterpretation. I've written the word interpretation, word recognized by law. It'll be completely misinterpreting the statute. In fact, one of the questions, and I don't want to waste your lordship's time, was asked, when you refer to person in 4.1, what does it mean? When you refer to person in 4.1, at that time they are unmarried. So you can't refer to them in any other way. It's as simple as that. I hope I've made myself clear. You couldn't have referred to them as spouse. Well, they were when you talk of two persons, and what it says is they should not have had a spouse. Otherwise, they can marry.
Yes.
So persons in 4.1 can only mean persons who are unmarried. So to interpolate into that the concept of spouse is wholly alien. You remember that, so I won't take you to the statute, that's all.
Yes.
Then Millard's declaration of a substantive right to marry and its legal recognition. Petitioner before the court are seeking a declaration that this court confers on same-sex couples the same rights that are available to heterosexual unions. Recognition of same-sex unions can take place in two ways, either through legislation which confers recognition to same-sex and LGBTQIA unions, or through a declaration by the court holding that such unions should be recognized by law. Therefore, the court must consider the following. One, does the fundamental right to choose your partner include the right to marry, divorce, a legislative enactment recognizing such marriage? Two, if the answer is in the affirmative, then is the state obliged to legislate and recognize same-sex marriages and accordingly confer the same attendant benefits that heterosexual marriages have? Implicit within these two assertions by the petitioners are two assertions by the petitioners. First, that opposite sex and same-sex couples are part of the same class. Well, this is completely conceptually erroneous. Therefore, there can be no discrimination between them under 14 and 15. Second, that a marriage is a union between any two persons irrespective of their gender and sexual orientation. Hence, the right to marry under 21 includes the right to be legally recognized by the state as such. The union between heterosexual couples recognized within society, even in the absence of law, is a sociological phenomenon, the organic evolution of which has endured thousands of years in different forms. Well, and I won't read it further, I'll just show this to your lordships, that what has been happening in Europe and actually in the developed world over the years is there has been a breakup, an atomization of the family. And because of the atomization of the family, problems have arisen, Mullahs. Divorces take place, people start living with each other. And Mullahs, therefore, the need to regulate came to Europe much earlier than it has come here. The atomization of the family has started here because of the process of economic liberalization and people having their own dreams to Mullahs follow, so to say. So it is this process that needs one, recognition, two, needs evaluation, and three, needs legislation. So first recognize, then you evaluate, then you legislate. You don't have a declaration from the court saying, this is what we decide. So therefore, in paragraph 6 here, Mothers, of this part, consequently, individuals started exercising choices, such as issues of divorce, custody, maintenance, amongst others, were required to be addressed and regulated. This could only happen through the medium of law. Therefore, for the first time in 55, Parliament enacted the Hindu Marriage Act of 1955. Now, I heard somebody say in the Oxford Union that, we are a vote bank. Tomorrow, the politician will have to run after us because we too have votes. This is the dynamics of society and within society. You should allow that dynamics to play out. You have to allow that dynamics to play out. Then Miller's 7 is important from our standpoint. These historical developments in the context of societal and community standards prevailing from time to time demonstrate that heterosexual and same-sex couples were not only perceived as belonging to separate classes, but that the legislature chose not to recognize and regulate heterosexual marriages as distinct from non-heterosexual unions. Therefore, the contention of the petitioners that the court declares same-sex unions and heterosexual unions as belonging to the same class is belied both by history and legislative intent. Because their argument was that this, and your lordships also mentioned, this has been there for centuries in India. So in 1955, when the law was enacted, Parliament knew and chose not to declare them mullahs. That itself gives you, that itself proves the legislative intent that we didn't want to include them here. So both historically and through legislative intent, they don't belong to the same class. They can't. So this whole argument of 14 and 15 is a non sequitur. So then I discussed NALSA, which is gender identity. I don't have to say anything more on that. I've already said what I had to say. Then Puttaswamy, your lordships, I've quoted the paragraph. Your lordships have dealt with NALSA in Puttaswamy. So I've quoted that paragraph. I won't trouble your lordships. Then human dignity, the aspect of human dignity and privacy, the relationship between dignity and privacy is para 13. And then Navtej Johar, which elaborates upon the concept of privacy with reference to an individual's sexual orientation, which is fine. Then privacy in public spaces, para 15 is important. The choice of sexuality is at the core of privacy. But equally, our constitutional jurisprudence must recognize that public assertion of identity founded in sexual orientation is crucial to the exercise of freedoms. So you need to be, nobody can discriminate you if you publicly identify yourself. That also is part of privacy. Then Miller's autonomy and privacy. Autonomy and privacy, para 16, are inextricably linked. Each requires the other for its full realization. Their interrelationship has been recognized in Puttaswamy. Privacy postulates the reservation of a private space for the individual, described as the right to be left alone. The concept is founded on the autonomy of the individual. The ability of an individual to make choices lies at the core of the human personality. The notion of privacy enables the individual to assert and control the human element, which is inseparable from the personality of the individual. The inviolable nature of the human personality is manifested in the ability to make decisions on matters intimate in human life. The autonomy of the individual is associated over matters which can be kept private. These are concerns over which there is legitimate expectation of privacy. It has nothing to do, Malaj. See, the moment you cross the boundaries, the contours of privacy, you come into the public space. Within the contours of privacy, you have complete freedom. The moment you go beyond the contour, well, then societal responses, debates, discussions, acceptance don't give you that absolute right to be recognized. So then, Malaj, sorry.
In the absence of an interfaith marriage law,
Yes.
what you are saying is, in the absence of an interfaith marriage law,
Yes.
which regulates intercaste and interfaith, could you have gone and said that I am not enabled, so make a law? I have a right to marry.
You could have, you marry, Malaj. Nobody will dispute that. Who prevents you from marrying? What you're asking for is not that, Malaj. They are married. The problem is not that, Malaj. You can call it by any name, which is why, Malaj, it's really not necessary for your lordship to say marriage is part of 21 or 14. Marriage is a union of people. It's inalienable. I have a right to be together with anybody I want, maybe same sex, maybe heterosexual, maybe anything. This is the problem. It is the recognition which matters. It's not the union which is a given, Malaj. The heart of the issue is recognition, Malaj. What? Now, Malas, paragraph 19 at page 9. Consequently, both same-sex and opposite-sex marriages are premised on the same human needs of love. This is the argument. Affection, stability, longevity, legislative regime is built around dynamics that are unique to heterosexual marriages. So too, a new legislative regime for same-sex marriages will have to respond to the unique characteristics and challenges that same-sex couples face. That's what's important, Malas. They will face different challenges. Let us for a moment assume that Parliament makes a law only with reference to LGBTQIA plus unions, as it has done for the transgender community. Would such a law be liable to be struck down on the ground that there can be no separate law for same-sex unions because they belong to the same class as heterosexual? I submit that such a law, if made, can never be struck down because different procedures will have to be evolved in the unique context of same-sex unions. The consequential issues that are bound to arise when dealing with reference to such unions may not be relevant in the context of heterosexual unions. Therefore, the petitioner's contention that they are being denied equal protection of the law by virtue of them being excluded from the SMA is liable to be rejected. The contention is based on an incorrect assumption. Both society and the law must consider them as belonging to unions of the same class without reference to their sexual orientation. Therefore, the exclusion of SMA is not violative of 14. So this is on the Article 14. Well, that I'm done with that. Now 21. Any form of union between individuals is a matter of choice. Such unions are protected under the right to privacy under 21. This in turn culminates in the right to marry a person of one's choosing. However, it is submitted that beyond the choice of one's partner is the legislative recognition of such choice, which in itself cannot be a fundamental right for the reasons that follow. The petitioners rely on the following
Just 1 minute.
It is
It is,
That in
and then if you
Gets
take it slightly wider
Yeah.
in terms of that concentric circle,
Yeah.
the largest circle, the
Yeah.
broadest argument is there is no fundamental right to claim any legislation. You have a fundamental right Negative rights, positive rights.
Negative.
So if they are infringed, you come to court or enforce it.
Right.
But there is no right to claim a legislation or a legislative
That's
regime.
precisely why we have the Constitution.
19 right.
Precisely for that reason. In an orderly society, you need the rules of the game to be played out on certain fundamentals. And that fundamental law is the Constitution.
So you are saying that the
And the
drill down of this whole case is that what is being claimed is a legislation,
Yeah.
a right to
a legislative recognition of the institution.
That's what is the heart of
Therefore,
it.
your submissions really say, okay, go ahead and get married.
Yeah.
There's no restraining an individual
That's
from
right.
getting married, even if you belong to the
You-
same sex.
Yes.
But
actually
you
the
can't really
Short of-
insist on
Yes.
the
I think
legislature enacting a law.
Short of court recognition.
Yes, exactly.
actually the solicitor did say something on that, but you're building on it and
Yes, yes. We always build millets on the
yes.
on the basis of what? That's what ultimately all science builds on failures, Mullas.
Yeah, these
Yes.
are new territories.
I'm
that
building on
we-
success.
If I am
Now-
looking ahead, I'm standing on the shoulders
Yes,
of big
yes.
giants, is what he said.
Now, Mullas, para
Bernard
25.
Bernard Shaw said that.
That's right. I was trolled, Mullas, thinking that I'm sitting on this side, Mullas. But I'm assisting the court, I'm in no side. Para 25. The petitioners rely on the following three judgments of this court
If
to
social acceptability is the test, I'm not sure whether your arguments are socially acceptable to the other side. That's the test.
That's right.
What's recognition is what?
No, we do our best, Mullas, to the best of our ability, and we need to take it forward. Don't need to be anachronistic, Mullas. We must recognize the reality, both in terms of aspirations as well as on the ground.
And ultimately, Mr. Sibal, the human race always survives on a sense of optimism of a better future.
Always.
And that's what we live on as well as judges.
Absolutely, absolutely.
Absent that, what are we doing our job for?
That's why we are here, Mullas, as partners in this enterprise. Absolutely. The petitioners rely on the following three judgments of this court to assert that a right to marry is recognized under the Constitution, which must be extended to same-sex couples. However, I submit that the contours of this right evolved under specific factual. Well, none of this relates to same-sex. Your lordships will remember in Shafeen Jahan what happened. That young lady.
You can skip that, actually.
Yeah, so we all know that. So, Mullas, then comes to Mullas, very interesting on Puttuswamy. But what your lordships relied upon. The
Mr.
whole.
Sibal, you know what happens is when you write, and this is really letting out a bit of a secret, when you write, you're also trying to push the paper as a judge. If you didn't do that, I mean,
That's true. That's true. That is true.
in everything that you write, you're trying to
No, but that's
push the limits, so to speak.
But that's exactly what should be done, Mullas. Ultimately, the law has to evolve in the context of changing times.
And that's what the legal arguments would be also. to
Yes.
Take it to a next level.
That's right. Absolutely. So, Mullas, your lordship talks about, sorry. 30, Malaz, what Aristotle said is true even today, Malaz. I just read that quoted by para 30. Greek philosopher Aristotle spoke of a division between the public sphere of political affairs, which he termed as polis, and the personal sphere of human life, termed oikos. This dichotomy may provide an early recognition This dichotomy may provide an early recognition of confidential zone on behalf of the citizen. And then Aristotle's distinction between the public and private realms can be regarded as providing a basis for restricting governmental authority to activities falling within the public realm. On the other hand, activities in the private realm are more appropriately reserved for private reflection, familial relations, and self-determination. I won't read further, Malas. Your Lordship's quotes other things, but this is rather instructive. Para 31, further the court dwelt upon the right to be let alone. Malas, let's leave that. Roscoe Pound, we can leave that. And then, Malas, so para 34, Malas, after I've quoted all this, para 34 at page 13, the right to be let alone or left alone, which necessarily contemplates a negative obligation on the state and on society to not interfere with choices that impact no one other than the person making them. However, where the exercise of the right to privacy has a public dimension, the state may create regulations in the larger interests of the community.
The right to be left alone.
Yes. So it is submitted that the legal recognition of marriage goes beyond the private sphere into the public domain, it being an institution with ramifications for society at large, to hold choice to be the basis of any form of LGBTQI plus union, and their recognition cannot ever be a fundamental right. Societal standards evolved over centuries and have a vital role to play in any exercise of recognition by the state. The state has regulated the parameters of choice within the conspect. There's something wrong with us. There should be a full stop. Within the conspectus of marriage, whether that be in terms of the number of partners, bigamy, polygamy, or in terms of the age of marriage. This regulation is based on societal propensities, which for better or worse, guide the legislature in the choice of its policy. If individual choice or the choice of unions were to be the basis of the grant of legislative status, then any form of union amongst individuals could receive such status. That by law is impermissible because no fundamental right is absolute, and the contours of exercise of each fundamental right are determined by law, but subject to interpretation by the court from time to time in the context of new challenges faced by society as it evolves. Then, Mullahs, I've dealt with Obergefell and Mullahs, the four principles. I won't read the judgment. Obergefell relied upon four principles, and according to me, completely wrongly. Because the four principles were relied upon in the context of Zablocki, which was payment for parental care before you can marry, which had nothing to do with the right, and loving, which was interracial. And from these two judgments, they extracted the principle that they laid. I just want to...
Which was the first one?
Zablocki.
Zablocki and then loving. Those are the two judgments. And both are irrelevant to the issue.
No, loving would be...
Interracial.
Yes, akin to intercaste.
Because it was heterosexual.
But it was as intensely...
Yes. But Malas, we are in a different... I agree, Malas, but we are in a different sphere altogether.
No, look at social processes. It was as intensely contested.
True.
As intensely...
True.
If I may use the word, shocking or blasphemous.
Absolutely. That is true, Malas. I'm just, Malas, trying to indicate to your lordships, Malas, the issue was not that at all. Then 38, this is important, Malas. Therefore, the submission that the right to marry and its recognition in respect of the LGBTQIA+ unions is embedded in 21 is therefore untenable. While it is true that those who are part of the community are entitled to choose their partners and declare themselves to be by usage or custom to be married, its recognition would still involve legislation through Parliament or the state legislature, as the case may be, since entry 5 is on the concurrent list. It's exactly, Millard's, what my Lord has been, Millard's, debating throughout the day. Therefore, while the right to choose one's partner may be within 21, there exists no unqualified right to legal recognition of such marriage by the state. Then foreign judgments, Millard's, Gaidan I have dealt with. I'm not, your Lordship is aware of it. And I said, this is ultimately, once you give the recognition, that two-pronged recognition that I'm talking about, then the litigation will go the Gaidan way. Then Gaidan I have dealt with. Obergefell, Millards, again. Millards, I just want to read, if your Lordships don't mind, the quotation. Because remember, even in the United States, it was only in 2003 with the judgment in the Massachusetts case, Millards,
Lawrence.
that for the first time it was recognized. That's the Goodrich matter. Now, Millards, I want to just, where is Roberts?
Roberts is gone.
Huh? Well, just give me a minute. Well, just come back to page 13 if you don't mind. Well, I'm sorry. Yes.
13.
I just wanted to read Chief Justice Roberts, just a couple of paragraphs, if your Lordships don't mind. Para 37, and just the quotation, Mullahs, if I may read.
Yes.
But this court is not a legislature. Whether same-sex marriage is a good idea should be no concern to us. Under the Constitution, judges have power to say what the law is, not what it should be. People who ratified the Constitution authorized courts to exercise neither force nor will, but merely judgment. Although the policy arguments for extending marriage to same-sex couples may be compelling, the legal arguments requiring such an extension are not. The fundamental right to marry does not include the right to make a state change its definition of marriage, and a state's decision to maintain the meaning of marriage that has persisted in every culture throughout human history can then hardly be called irrational. In short, our Constitution does not enact any one theory of marriage. The people of a state are free to expand marriage to include same-sex couples or to retain historic definition.
Partly Holmes's formulation.
Yes, partly. Right. Now, Millards, I was now I finished Gaidan. I'm not going to trouble your Lordships. You're fully aware of the judgment. Then Obergefell versus Hodges I've done. Fody, Millards, Fody also. Yes, in Fody, it's what's important, Millards, para 52, if your Lordship don't mind. Page 18, the quoted portion. Has the public had an opportunity to have its say? For the purposes of the present discussion, I assume that the extent to which the public has been consulted would be a relevant factor in determining the appropriate remedy to be ordered. Even making that assumption, the contention by the state and the amici to the effect that the matter is not ripe for determination by this court cannot be sustained. The stark claim that the public has not had an opportunity to engage with the issue is not borne out by the facts. A recent memorandum of SALRC on domestic partnership testifies to prolonged and intensive engagement with the public. The memorandum establishes three things. First, there has been extensive public consultation over a number of years. Secondly, a final SALRC report can be placed before Parliament within a relatively short period. Thirdly, the report can be expected to contain a comprehensive proposal intended to provide appropriate relief, which is in a format quite different from that which the applicants propose. The matter of the relief to which some same-sex couples are entitled would therefore appear to be ready for prompt consideration by Parliament. The orders to be made by this court should be taken account of this fact. This was the extent of consultation, Millards. You look at Obergefell, same thing. Look at Fody, same thing. What we are being told now to your Lordships is Parliament, don't go to Parliament. Parliament will not do any of this. Please, you do it. It is completely inconsistent with what's happened in other jurisdictions. Para 53. It's important to note that the presence of meaningful public engagement is not the same as public consensus. For if it were, the general value of democratic decision-making would override individual rights, which is what my Lord Justice Bhatt said, and it's right. You don't have to have consensus on these issues. This is even more apparent in the judgment of the Constitutional Court of Taiwan, which counts as public engagement over a decade's worth of failed legislative attempts to legalize same-sex marriages. However, that engagement, which manifests as Law Commission reports, bills in the legislature, referendums, high court decisions, state legislations, is absent in India. Therefore, it is apparent that while there are liberal democracies such as ours granting legal recognition to same-sex marriages through judicial decisions, such decisions cannot be imported into India without a reference to societal context. So public engagement goes hand in hand with another approach, a form of approach. I know something's wrong here. Countries that have conferred state recognition on same-sex marriages, incrementalism. This necessarily meant steps by the judiciary or the legislature towards the recognition of the rights of same-sex couples, either before or after a declaration of marriage equality. For instance, Mexico City recognized the cohabitation partnership of same-sex couples and their marriage since 2009. At the federal level, Supreme Court of Justice declared as unconstitutional any federal law that considered the purpose of marriage to be procreation. So all that happened. Sodomy, Mullers, South Africa, and Mullers, you had Stachwell relating to pension rights. You had Detroit relating to parental rights of permanent same-sex life, and then Fori recognized the equal right of same-sex couples. So this has been incremental. It always has been incremental. On the other hand, Portugal gave same-sex couples the right to marriage through legislation, but has not yet bestowed the right to adopt. Similarly, the Belgian Parliament in 2003 recognized the right of same-sex couples to be legally married, and later in 2006 granted the right of adoption. So there is no set pattern with respect to the route to legislation of same-sex marriages and a conferral of the attendant rights, depending on the issues of federalism, of the relationship between judiciary and the legislature, and of the synergy amongst law, society, and religion. Countries have taken steps that suit their unique circumstances the best, which is why I say that we should not rely upon these foreign judgments at all. So, Mullahs, then I quote the order in Nalsa. Well, as your lordship is aware of it. But what's important is what I have said in para 61 at page 21. And I'll leave it. Therefore, instead of limiting its judgment to the reliefs prayed for by the petitioners, I submit that this court needs to address the following issues. Whether the LGBTQI plus community, being a sexual minority in a democracy, I changed the word, Mullahs. The lordships may change that for me. In a democracy, is entitled to be protected even in the absence of a law, given that their sexual orientation is different from heterosexual persons. The necessity of procedures which recognizes, without conferring the status of marriage, the impediments that come in the way of the LGBT unions. 3, the necessity of administrative procedures, as the government has suggested, and guidelines recognizing that sexual orientation is a physiological phenomenon and the same-sex unions involve intimacy outside the heterosexual world, and that such unions cannot be discriminated against. The above is possible only when the LGBT community is recognized as a sexual minority in tandem with the recognition of transgenders having a separate and unique gender identity, which now has been recognized by law. Once The above is possible only when the LGBT community is recognized as a sexual minority in tandem with the recognition of transgenders having a separate and unique gender identity, which now has been recognized by law. Once the court, through a declaration, recognized the community as a sexual minority having a separate and unique sexual identity, then issues with reference to civil rights, such as adoption, gratuity, surrogacy, can be addressed by government through stratagems which may involve administrative solutions, both within the government and the public sector. Till Parliament addresses the issue of legislation, the government can, through executive actions, consider the recognition of certain rights which are necessary in the fulfillment of the aspirations of the LGBT community. Then, the next part of it, I don't want to deal with because it deals with the Special Marriage Act. I don't think that's necessary, Malas. All that I say at the end is, in a way, this moment should be celebrated, that your lordships are at least dealing with the reality of the situation. But that celebration must not result in an overreach. Though it must recognize the reality and set systems in place for the state to move forward. But without moving forward, Mullets, many of these people will be discriminated against. How that is to be done, in what manner it is to be done, Mullets, I think that the government can ponder over it. But as for me, Mullets, I think that what they've asked for is not a fundamental right. What they must get is something short of it, but something that's meaningful. Thank you very much.
Thank you, Mr.
Sorry.
Yes.
Lord. My Lord, I have submitted written submissions, which I hope your Lordships have got, of 12 pages. And there is a brief compilation. To the extent possible, I've tried to avoid. Not this was prepared on 2nd of May. So to the extent possible, I've noted the submissions and tried to deal with issues not dealt with. My humble request is, as I go along, if your Lordship feels this point is covered, just ask me to move on, because we have to, others also have to argue, my Lord. My Lord, I have basically 6 grounds in my written submissions. And if your Lordship takes page 1, my Lord, the first proposition which I wanted to make was, a lot was asked on, is there a fundamental right to marry? And my submission in my first part of my note is that, if your Lordship has got my note,
Yes.
the 3 cases, Puttaswamy, Shafin Jahan, then you have Navtej Johar, when they use the word right to marry, they really were meaning the right to cohabit, the right to live as a union. There was no concept of a marriage in the sense of the Hindu Marriage Act or the Special Marriage Act. Now, my Lord, the same-sex marriage, I did some research. I could find it only in para 479 of Puttaswamy, of Justice Nariman's judgment, where, if your Lordship kindly sees at page 2, his Lordship says, rights of same-sex couples, including the right to marry. Lordship has got the bold, yes. Now, this is a bit ironical because this judgment was delivered 1 year before Navtej Johar. So at that time, it was an offense. So it could not be a fundamental right to marry. So, but anyway.
No, but in Puttaswamy, we had expressly cast doubt on the judgment which overturned Nas Foundation.
Correct, Nas Foundation, yes. So in that sense, yes, but I'm just saying that this was recognized. Now, please come to para 126, 167 of Navtej Johar, where then, my Lord, the Chief Justice has set out what was the stand taken by the petitioners at that point of time. 1.3, Lordship has got 1.3. The above authorities capture the essence of the right to privacy. There can be no doubt that an individual has a right to a union under Article 21 of the Constitution. When we say union, we do not mean the union of marriage, though marriage is a union. As a concept, union also means companionship in every sense of the word, be it physical, mental, sexual, or emotional. The LGBT community is seeking realization of the basic right to companionship, so long as such companionship is consensual, free from the vice of deceit, etc., etc. Now, my Lord, what my submission is, when your Lordship says there's a fundamental right to marry or a right to marry, the Lordship is basically declaring a law, and I'm going to come to what is the status of a court declaring a right when I come to the 6th part of my submission. But now, once the Lordship says, for example, in Navtej Johar, that you decriminalize a gay relationship, from that time onward, the law declared by the Supreme Court says that it's no longer a crime to have a same-sex union. And that's what it stops. Now, but to go one step further is a totally different aspect. Now, once the court says that a same-sex union is not illegal, is not a crime, from then on, any legislation cannot say that if 2 people of the same sex cohabit, it will be an offense. That's the law declared by the Supreme Court. Unless that law is changed by an amendment of the Constitution, that will be the mandate. And I give examples where once your Lordship declares the law, and Lordship will kindly say Article 13(2) says law includes. It is not just Act of Parliament, notification, regulation, custom having the force of law. I would say a law by Parliament is X. The interpretation played by your Lordship is Y. And X plus Y will become the law declared by Parliament in future. Now that can be changed as per Prithvi Cotton Mills by reviewing the basis of the judgment and so on. But once your Lordship says there's a fundamental right to marry, It is a recognition that they have a right to cohabit. It was not used in the sense of marriage as in the marriage law. That's the first proposition I'm making. Now, my lord, I've just given examples of how the parliament has overcome judgments which it did not find, like for example, whether in reservation cases or in 46th Amendment, etc. When Supreme Court said, yes, you can't levy tax on works contract, they made the 46th Amendment. When they said you can't cross 50% limit in promotion, they made it. EWS. It was said that economic criteria is not a criteria. Mandal said that. Indira Sawhney's case. But the Lordship
Which
made
one
the
of them
amendment.
relates to a fundamental right?
Pardon me?
Which one of them relates to a fundamental right?
I beg your Lordship.
Which one of these
These
relates to a fundamental right?
The right to marry.
Apart, no.
Fundamental right.
You see, when you're giving these examples, A, B, C, D, E,
Yes, yes.
none of them actually relate to a fundamental right.
No, I'm not saying that.
Anand Dunkerley or
I'm saying what's the law declared by Supreme Court. Lord, I'm going to come to derivative rights and enumerated rights a bit later.
Yes.
Lord, I'll get your Lordship's point. I'm going to come to that later. What's an enumerated right and what's a derivative right? What is the status of a derivative right? I'm going to put that proposition. But all I'm saying is, when you say fundamental right to marry, proposition one is it meant marriage in the sense of cohabitation, in the sense of peaceful union. And secondly, once the court says there's a right to marry, that becomes a law. Future legislation will have to take that into account. It can't transgress that unless that judgment is set aside. Now, please come to the next proposition. Well, I'm going a bit fast, if your Lordship.
No.
Prohibits debate in parliament.
Pardon me?
Prohibits debates in parliament.
Yes, as learned solicitor says, that also prohibits a debate in parliament. Once the Lordship has said there's a right to marry, parliament cannot then debate that there is no right to marry. We are going to. I'm just making the proposition. Yes. What's the meaning of a law declared by parliament? And when you say fundamental right to marry, what it means. Now come to Special Marriage Act. Now, if a Lordship comes to the prayers in the writ petition, in my compilation, at page 117, Lord, there are totally 20 writ petitions. And when we decide this list, my Lord, the writ petition, we must also bear in mind what are the prayers. And my Lord, my colleague Mr. Amanja has taken the trouble. Please come to page 117.
Of your compilation.
Compilation, yes. Lordship got it? No?
Yes.
Page 117. Now, just to save your Lordship's time, there are totally, from page 117 to page 125. My Lord, this call has got it? No?
Just getting it.
Index to come. I'm sorry, but I'll just wait. I'll just wait. But out of 20 writ petitions,
Yes.
12, my Lord, Justice Call has got it?
Yes.
Yes. 12 directly challenge various provisions of the Special Marriage Act. Some section 4, 7, 8, 9 schedule. Some want to declare the entire law invalid. Then, Lord, I'll just make a note. Lordship will just kindly note. 117 to 125 are challenges to SMA. 125 to 128 are challenges to SMA plus some other act.
How many in number?
Total 20 writ petitions.
No, 125.
Yes. Now, if your Lordship wants, only SMA 12 writ petitions.
Yes.
Then SMA plus other acts are 13, 14, 15, 3 writ petitions. 13, 14, 15. Then, my Lord, only Hindu Marriage Act are 16, 17, 18, 3 writ petitions. Foreign Marriage Act, 1 writ petition. Citizenship Act, 1 writ petition. Lord, I've just summarized, we have summarized to the extent possible what are the grounds of challenge. So now I come on, sorry.
Yes.
So, my Lord, this table will give your Lordship what are the cases before your Lordship, what have they challenged, what grounds they have challenged. Lord, 20, I don't know if any new writ petitions have been filed. I've also not dealt with the interventions, I've just dealt with the basic writ petitions. Now I come to the second point, which is at page 4 of my submissions. Whether the Special Marriage Act is ultra vires Article 14, 19, 21, Lordship can also add 15 there. Now, my first submission is And Your Lordship, just make a note of it. In my compilation, at page 1 to 3, I've set out the statement of objects, but Your Lordship has repeated several times. It's a law to permit interfaith marriages. Now, the proposition I'm making to Your Lordship is, if a law has been made to solemnize or legalize interfaith marriages, then the validity of that law made in 1954 cannot be tested on the ground that it doesn't provide or doesn't permit the recognition of same-sex marriage. Whether you apply the Ramakrishna Dalmia test or the arbitrary test, we must test the object of an act by the object for which Parliament made it.
The stated object.
The stated object. In 2.3, I'm come to only one exception, where a law made for a particular purpose at that point of time would fail subsequently, and that is the maxim of Cesante ratione legis, Cesante ipsa lex, and that's the reason why Your Lordship struck down or diluted 377, because the section says carnal intercourse against the order of nature, and then the Wolfenden report and medical science clearly said there's nothing unnatural, there's nothing unlawful about it. So the very rationale for the law went. It was on some biblical thing of
In
that.
case a law cannot be struck down on the ground that its coverage is not wide enough to cover
Everything that,
everything
that it
ought
ought to
be
cover.
covered.
Under inclusiveness. That is covered by just.
Say,
Under classification.
Under classification or under
Yes,
inclusion law is a valid law.
Yes. And that's been dealt with Ajit Mills by Justice Matthew. Please come to Ambika Mills. Please come to 2.4. Exactly what Your Lordship.
Regulate something.
Yes.
Pardon me?
You don't have to regulate
Everything.
Regulate
Yes.
something.
Yes. Yes.
If you want to give something, it doesn't mean that everybody has to get it.
Correct. Correct.
And that's why the classical statement that it is open to the legislature to recognize the degrees of evil.
harm, and yes.
Degrees of harm. And what Your Lordship is saying is echoed. I mean, it's
You
by
can
Justice
leg- you
Matthew
can
at
legislate
2.8.
in phases, you can legislate in parts,
Parts.
you can cover a part of a social problem even at a given point of time.
Even in the case of personal laws, this has been used even more.
Yes. Yes.
They said you can do it in phases, looking at this.
What they call the marginal gains. You go incrementally in.
Step by
No,
step.
sorry.
So you can't
Yes.
challenge a law on the ground that it should have gone much broader or wider than it has.
Yes. But
That's
my,
the
yes,
test for the legislature.
why I said so was because most of the writ petitions seek to strike down certain provisions of the Special Marriage Act and Hindu Marriage Act. And I'm saying that, look, these are newly recognized rights. You can't now strike down a 1954 law on the basis of some rights that come later, which I will come to later when I come to it. Now, my Lord, in the light of what my Lord the Chief Justice mentioned, exactly what Your Lordship said.
Judicial response.
My Lord, I
Their argument is it will be a disproportionate judicial response, therefore include us.
But I'm going to use the expression that will amount to judicial retrofitting when I come to it later.
No, but even if they are right in asserting,
Yes.
even if they are right in asserting
Right.
that same-sex couples are entitled to the benefit, I mean, for testing their hypothesis, that a same-sex couple is entitled to the benefit of the institution of marriage. Because as they said, we are not really despising marriage, but we want to have the benefit of the institution. Even so, you cannot challenge a legislation on the ground of discrimination on the ground that it included only a part of the
Exactly.
community within its field.
Right.
That's one argument. And
Right
second,
to association,
Yes.
remember Damayanti Narang.
Yes.
Right to association, in that classical sense, right,
Yes.
is essentially a right to exclude.
yes, yes.
So if you liken, I mean, taking your argument, liken marriage like a club, like this is meant for so and so, so and so, so and so. Implicit in that formulation is that those others cannot be made part of this or members of this club.
Yes.
And Mr. Datta, there's another reason for it. Because in that case, if you strike down the law on the ground that it is under-inclusive,
Everything.
that will not then result in the
Benefit them.
creation of a law which is broadly inclusive.
It won't solve the problem.
In fact, that's what happened to us when we had this challenge to the distinction between the ages of marriage for women and men. 18 for women and 21 for men. Justice Narasimha and I got that challenge. But the answer was simple. I mean, that's for the legislature to increase the age of marriage of women to 21. If we strike down the age of marriage of 18 for women, you'll have no law on the subject at all.
Yes. Lordship is right. Yes.
That's one of the reasons why an under-inclusive law is not struck down.
Yes.
An over-inclusive law can be struck down because you are treating unequals equally.
The only reason perhaps is if you start a new law and then, for example, let's say you have, you take a class of people and you deliberately omit somebody, then will it be under inclusiveness or you left out somebody? What's the reason? That will be a separate issue.
That is that hyper classification issue.
Yes, hyperclassification. Yes. Of the same genus, then you can't exclude
You
somebody.
can put yourself in that and say this is an artificial wedge.
Yes.
Then that.
Then that. Now,
Therefore, the alternate argument, which is don't strike it down.
That's right.
But read in an under-inclusive law to make it
All these to the
broadly
extent of
according to
caution.
This is that.
I'm going
thinking-
step by step. There are three
No, first we're
interpretative
dealing
tools.
with unconstitutionality.
Milord, there are three interpretative tools.
Second is
Reading down,
sorry, you said.
adding words, and the other one is what's called the third category, updating construction. So all three can, I'm going step by step. I'm saying first you can't strike it down. That's my first submission. And on under inclusiveness, kindly just see, Milord, the para 2.4.
Ambikan.
This is Matthew. This is Matthew.
So shall I skip it, Milord? Or shall
Yes.
Okay, yes. Now Lordship will kindly come to same thing in
The doctrine of
Eclipse also.
Eclipse judgment also.
which one?
The doctrine of eclipse.
Where?
Eclipse in the
Eclipse.
fundamental right sense.
Vikaji Narayan Dakras.
Which one?
Just Matthew discusses the doctrine of eclipse also.
Yes.
in this one.
Datar, it's a.
Yes. It
Old-
discuss about the companies, whether company can be a citizen and.
No. Sundaramaiah, if you remember Sundaramaiah.
Yes.
Constitutional prohibition.
Yes.
Then that later, which is that 59, Deep Chand.
Yes.
Then this is the third one.
Voidable issue and so on.
What happens if a law infringes a provision of the Constitution? Is it stillborn, or does it come under an eclipse?
My lord,
If it comes under an eclipse, then the shadow is removed when the eclipse is removed.
and then become proprio vigore.
It's gone and gone forever.
America has talks of that
My
because
lord, there is
it deals with
a very serious problem in that. I've made an article also, I put in Bhopal. T.L. Venkatramayar is the author of that question of distinction between a law void for lack of legislative competence
And the
and the
prohibition.
word lack of for constitutional limitations. Now, when the first Pesikaka case came, it came before a bench of three judges.
Three,
There was a difference of opinion. Then it went before five. Justice Venkatramayar, sitting in a bench of three, had made this distinction of between legislative competence and voidness. When it went to five, the five-judge bench expressly said, we don't accept this distinction. In spite of that, in Sundaramaiah, he's brought it back. That's a sad thing, but anyway, that's now become the law of the
The
land.
departure went into in Deep Chand.
Yes.
Because 13.2 is as much a prohibition
Yes.
to the legislation
Yes.
as in the case of 245.
Lord, in fact, Justice Kaul has reserved a judgment. We argued at great length on the meaning of voidable in the context of Subramanian Swami's case. Lord, you strike down the distinction between that section
Yes,
6A,
yes.
you classification. What happens? The law came in 2004. You strike it down in 2014. What happens in between? Then you got this British concept of the theory of second actor. All acts done in between, what happens? But what I'm submitting is, I'll just skip this question of under inclusiveness. Same thing was mentioned in Navlaka's case, which is at page 5. Right? So under inclusiveness, so I'll skip that. Lordship knows the proposition. Now come to para 3, third part of my submissions. What are the limits to altering provisions of the Special Marriage Act? Now, Lordship will kindly cease to start my motion. Yes. Now, if your Lordship kindly sees, some of the prayers say, and I think Mr. Mukul Rodli's submission also says they gave a chart. Replace this word here, replace that word here, and then you will get the solution. Sorry.
Just
No, sorry.
at that extract, a judge must not alter the material of which the act is
The
governed.
C4 quote as
point of discussion.
there's a repeated again.
All seems to be locked out.
Yes.
There is no, is that.
No,
No, it's there.
No, I think it's Lordship's.
frozen.
Yeah, you're right.
Frozen.
I don't know if he's.
Sanjay, Dekho, also right. The other call, you are.
Frame is frozen, that's correct.
Yeah, that is, the other call is on.
Yes.
Yes.
Yes. Now, Manoj, there I mentioned the famous oft-repeated case of Lord Denning. In fact, more equally beautiful than this, he says that English is not a perfect language. If you could, then it will be a divine prescience and so on. Then this last passage starts. So my next submission is, if you accept the written submissions of the petitioners, and start making changes, you're completely altering the fabric, which is not permissible by a court. Now, please come to what exactly happened in this case. In one case, well, there is a question of the court said that the right to speedy trial is part of Article 21.
7 judges.
Then it went to a further point. What is speedy? How many months is speedy? Then the court said in 2 cases, they said specific time limits. If the trial goes beyond this point,
2 years.
then the whole. And number of people started getting acquitted. Then what happened? It went to a bench of 7 judges in Ramchandra Rao. And I think Justice Raju took a dissenting view, but 6 judges held.
Justice Lahoti is.
Yes.
Justice Lahoti's judgment, Lordship is right. Justice Lahoti's judgment, they held that however desirable this speedy trial may be, the court can't lay down a parameter and say, no, this is the time limit. And then he quotes Wade's monograph, which is worth extracting. Kindly see, my lord. And that is the reason which I will take me to the next thing of polycentric disputes. Pardon me? Lon Fuller's Spider's Web, yes. Your lordship has quoted it also in one. There are 3.4. Please see, my lord. I would like to read this, my lord. The majority opinion delivered by a 7-judge bench of this court relied upon a cautionary note featured in the monograph Judicial Activism and Constitutional Democracy in India, which highlighted the difficulties the court would encounter while venturing into the domain of the legislature. It held in a monograph, Judicial Activism and Constitutional Democracy in India, recommended by Sir William Wade as a small book devoted to a big subject, the learned author, while recording appreciation of judicial activism, sounds a note of caution. It is plain that the judiciary is the least competent to function as a legislative or administrative agency. For one thing, courts lack the facilities to gather detailed data or to make probing inquiries. Reliance on advocates who appear before them for data is likely to give them partisan and inadequate information. On the other hand, if the courts have to rely on their own knowledge or research, it is bound to be selective and subjective. This is very important. Courts have also no means of effectively supervising and implementing the aftermath of their orders, schemes, and mandates. Moreover, since courts mandate for isolated cases, the decrees make no allowance for differing and varying situations which administrators will encounter in applying the mandates to other cases. Courts have also no method to reverse their orders if they are found unworkable or requiring modification. Highlighting the difficulties which the courts are likely to encounter if embarking in the fields of legislation and administration, the learned author advises the Supreme Court should have well left the decision-making to the other branches of the government after directing their attention to the problems rather than itself entering the remedial field. Yes. Now, my lord, here I want to mention that here, my lord, I've got
Sometimes there is one of the very distinguished lawyers here is to make this argument that if the court gives a declaration which essentially is part of the legislative domain and declares that this is possible and this should not be done, there is no manner for a citizen to come and say this is wrong because that's part of.
yes, yes. I'm going to come to, I want your lordship to lay down some law on what's the status of derivative rights. There's no such, but I'll just make my submissions. I'm relying on an article by Sirwai, but kindly see. Now, my lord, here I want to mention, stopping here for a minute. What?
Void.
Possibly, Mr. Sirwai, possibly what your lordships indicate.
The previous Attorney General said that. He used to make this argument.
Yeah.
Yes, Mr. Datta. Mr. Datta has 7 minutes to go. Huh?
I don't know if I'll finish. I'll try my best.
We'll wrap it up by 4 o'clock.
I'll try and wrap it up. Just give me 5 minutes more, my lordship. Yeah. Now, here I'm going to submit. If a lordship takes Vishaka was a guideline, but the Union of India accepted those guidelines. Take triple talaq. In the minority judgment of Kher and Justice Nazir, they said, yes, the union accepts that this is the correct position, striking down is correct. And also the All India Muslim Personal Board filed an affidavit saying the Qazis will be advised to tell the bridegroom not to enter triple talaq. So this is a concept of collaborative governance, where when the Supreme Court makes a declaration, filling up a vacuum or giving some general guidelines for the welfare of the people, if the union supports it, then it becomes a concept of collaborative governance. But if the union is opposed to it, my lord, then my humble submission is, those guidelines should not be issued. And here what I'm submitting is, Lordship will have to bear the difference between Article 141, where Lordship declares the law, whereas the making law is 246. And there's an ocean of a difference between declaring a law under Article 141 and making a law under 246, 247, etc. Now, Lordship will kindly see on para 4.
Correct.
It's coming in policy center. Lord, I won't take time on this limits of reading down, updating construction. Lord, Mazdoor Congress says you can read down, but you can't do the exercise if the provision is cast in a definite and unambiguous language. And my submission is the Special Marriage Act, the Hindu Marriage Act are very clearly cast. None of them call for exercising of the interpretation of reading down, adding words, or updating construction. Lordship will just make a note there. Para 4.1, 4.2, 4.3 are in the context of addition of words. Then 4.4 is updating construction. And my lord, much was made about the Madras High Court judgment of Arun Kumar, where they say the male pronoun is directly contrary to Madhu Kishwar in para 4.5. Now come to polycentric disputes. Now, my lord, this lawn full of spider's web, and why do I call it a spider's web? Lordship is to visualize entry 5 of list 3. It contemplates marriage, divorce, adoption, wills, intestacy, succession, joint family, partition, and other issues where customary law prevails. But I did a search. I put husband or wife in SCC. I got 542 hits in 542 places in different statutes. Some are, of course, repeal statutes. Put spouse. It comes in 233 places. So now, my lord, when your lordship is going to decide, if your lordship is going to put, as they prayed for, words into Special Marriage Act to give them recognition, then you are virtually entering into a polycentric dispute. Navtej Johar was monocentric, only 377. Shafin Jan was monocentric. Joseph Shine was monocentric. But this is a polycentric dispute where a large number of cognate provisions will be involved, and one cannot predict today what will be the side effect or the collateral damage or the collateral impact on other statutes. Now, my lord, 4.10 is, my lord, the Chief Justice has referred to lawn fuller with approval in the OROP judgment, my lord. Now, finally, I come to enumerated and derivative rights. Come to enumerated and derivative rights. Lordship said, what is the right to marry? Now, my submission is, right from A.K. Gopalan, it was settled law that part 3 are not exhaustive of all the rights. Justice Das's judgment is there. Now, right to life has been the source or the some kind of a Gangotri of so many rights. Status of these rights, derivative rights. Now, these derivative rights were first discussed in All India Bank Employees Association, where they said 62. Where, my lord, Justice Rajgopal Iyengar.
I know what you're saying, where he says that your right doesn't include the fruition of that right.
Yes. I got the right to form an association, but that does not mean that the Bank Employees Union has the right to ask for the accounts of the company so that they can decide how much more bonus they can claim. So he says that your right is to form an association, but you can't get automatically the right to make that basic right complete.
Fertilizer Kamgar Union also then took that.
Yes. And Maneka Gandhi quoted All India Bank with approval. I've quoted both those points. And therefore, my submission is, Lordship will just take seed-wise article. And this is a new point I'm making, your Lordship may kindly see, because Lordship keeps on evolving rights.
Where is the reference to seed-wise article?
Seed-wise article is at page 39 to 53 of my book. Well, I'm just trying to meet the 4 o'clock deadline.
Compilation.
Yes. Kindly come to page 48 at para 17. It's a wonderful article written in the context of the Privy Purses case. Of course, Mr. Sirwai felt the Sirwai prerequisite judgment was wrong. Why I use this? I was trying to find out. Lordship says there's a right to shelter, but it can't be implemented. There's a right to, Lordship just now mentioned right to education. What follows? I may declare right to marry. Then what happens? Right to roads, right to housing.
Does that mean that you don't recognize that right?
Yes, what I'm submitting is you recognize the right, but I'm putting a proposition that once you recognize the right, future laws must take that recognition into account. But there could be some derivative rights. Suppose Lordship says right to life includes right to shelter. In the Hoffeldian sense, it will not carry a corresponding duty that you must provide housing. So some derivative rights, and there are two categories of derivative rights.
From our constitution lexicon, you will say this is somewhat like a directive principle.
Directive principles.
Yes.
The lines of.
Yes, yes. Directive principles who are born out of a fundamental right. There, my lord, if you read minimum ills, they make very clear these are the desired goals of this thing. Here you say it is a right. If I got a right to life, I got a right to housing, I got a right to shelter, I got a right to food. All these are rights. Now these rights, there are two types. One are rights which are inextricably intertwined with the main right. Right to free speech and expression. In Ramesh Thapa, they say right to publish is part of free speech because the Supreme Court said you want to publish what you think, you don't want to talk to yourself. So that's an integral part. There are some rights which are derivative rights, which are derived rights, which I'm humbly submitting can be inchoate rights because, as Sirwa explains, there are certain rights which are exception to the concept of ubi jus, ubi remedium. There is a right, but there is no enforceable remedy. Mr. Sirwa mentioned in the context of this thing. Now, my lord, I'll just make my last submission. Yes, that's okay. Just 5 minutes, my lord.
Yes, Mr. President. The last submission.
Yes. Now, my lord, so there I mentioned about All India Bank and so on. Now I come to this by submission. If your lordship sees the Arbitration and Conciliation Act, surprisingly, in the 7th schedule, lordship will just make a note.
Yes.
In the 7th schedule to the Arbitration and Conciliation Act, conflict of interest, they use the word explanation 1. Kindly say explanation 1.
Seventh schedule explanation or
Explanation 1 in the 7th schedule, after para 19.
Yes, 1.
Lordship got it?
Yes.
The term close family member refers to a spouse, sibling, child, parent, or life partner.
Yes.
So they use spouse differently from life partner. So an arbitrator, perhaps if he's gay, and if his life partner is gay, then it becomes a conflict of interest. So spouse is not necessarily inclusive of life partner. Well, Lord, I will conclude my point just mentioning that the decriminalization of same-sex, your lordship's judgment in Navtej Johar, was really a historic moment. It will be a jewel in the crown of the Supreme Court, and I mean it, my lord. It's a huge impact of reading down a biblical-based law, which is completely anachronistic to a constitutional democracy. Your lordship declared that these people can live in peace. They will not be prosecuted under 377. They will have the same rights as all of us to live in peace, harmony, nobody disturb them. But my humble submission is, harmony, nobody disturb them. But my humble submission is, making that declaration is the constitutional border of the judiciary. Now, what rights further people, the same-sex couples must have? You enter the territory of the legislature under Article 246. Decriminalizing is 141. Developing it further is 246. And my humble request is, if your lordship now wants to include, answer the prayers, read different sections into Special Marriage Act, Hindu Marriage Act, I would use the expression, it will amount to judicial retrofitting. The definition of retrofitting is to fit a new part or a new component into an old machinery. Now, the recognition of right to marriage, the recognition of this right of same-sex couples, that there's nothing unnatural about it, they can live in peace. These are newly recognized rights, and it will be dangerous and lead to adverse consequences if these newfound rights are retrofitted into old statutes. My humble request is that prayer should be declined and the writ petition dismissed.
Thank you, Mr. Datta. So tomorrow morning, we'll commence with Ms. Aishwarya Bhati, then Mr. J. Sai Deepak. And sorry, Manisha will argue, Manisha Lavkumar will argue, and then Mr. J. Sai Deepak. We request each of you to take 20 minutes tomorrow morning. So that will take us to about 12:15 tomorrow. I think the interveners, what solicitor will do is, interveners may all put together maybe one-page notes, and they move it to Mr. Kanu Agarwal, and then he will just tender it to the court. So the interveners will now will be down to one. All right. So what we are planning to do is 20 minutes each to Ms. Bhati, Ms. Manisha Lavkumar, and Mr. J. Sai Deepak, which takes us for 1 hour. If Mr. Maninder Singh does not have greener pastures, another 20 minutes from Mr. Maninder Singh when he makes his presence here. So that takes us to about 12:35 tomorrow morning. So
Lord,
12:30 we should.
been said the road to heaven is. Lord, your lordships may perhaps, my lord, consider not to restrict it that, my lord, closely.
We done that, but if you don't do it today, we'll never be able to do it tomorrow.
Your lordships are.
All right, but the upshot of it is that at lunch tomorrow, we will wrap up the hearings from this side at lunchtime. Solicitor, for 5 minutes, you spend time and ration time between you all.
Yeah. My lord, I'll speak to them and, my lord, revert in the morning.
Also, as Justice Bud says, if everybody need not now read out extracts from judgments, etc., you can just give us a note, refer to the point. That's what Mr. Sibal, Mr. Datar also did today. So that really saved a lot of time when Mr. Sibal and Mr. Datar were arguing. So we request everybody else who follows also to do the same thing. If we have, the reason why we said this way, we conclude by 12:30, is that if you have some people who are left, we don't want to give the impression that we didn't hear someone. Somebody can argue for 2
Your
minutes,
lordship
3
would
minutes.
never give that impression.
So 2 minutes, 3 minutes, 5 minutes, at least there's a feeling that we heard the perspective. So, but so long as we have it at the back of our mind, and then between 2 o'clock and 4 o'clock, one of you will please sit down and ration time amongst yourselves, so that between all of you in 2 hours, we'll wrap up.
That the road to hell is paved with good intentions. We'll try to do it in 2 hours. But
2 hours tomorrow, yes.
We'll try.
We've now heard the entire controversy. We just have a very grateful.
Grateful, man.